what do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God! No!
Hey, everybody.
As you can see, we've had our eye on you for some time now, Mr. Anderson. Mr. Anderson. Oh, Mr. Anderson. Mr. Anderson. Mr. Anderson.
Mr. Anderson.
Mr. Anderson. Mr. Anderson. Mr. Anderson.
Mr. Anderson.
Mr. Anderson. Mr. Anderson. Mr. Anderson. Mr. Anderson. Mr. Anderson.
Mr. Anderson. Mr. Anderson. Mr. Anderson.
Mr. Anderson.
Mr. Anderson.
Mr. Anderson.
Mr. Anderson.
Mr. Anderson.
Mr. Anderson.
Mr. Anderson.
How we doing, everybody? that can go on for quite a while. How are we all doing here today? That's our new introduction for this, as long as this trial goes on. Great. Well, I'm glad y'all liked it. You seem to like that. So there we go. There was no boomerang involved. There's no boomerang involved at all. All right. Oh, there's more Mr. Anderson, Mike May. That goes on for about a minute and a half, but we'll ease into the full thing. So welcome, Carlos Delfino. I don't understand. Is Jeff's surname Anderson or what? Or this could be the Zachariah Anderson trial. What movie is that from? Oh, shoot. Nico Ace, love your cap. Yeah, this is from the Sugar House Distillery in Salt Lake City, Utah. Makers of some really, really amazing small batch whiskey. Yeah, well, great shit show at the trial. As the trial ends yesterday. Well, that's what we're here for. We're here to catch everybody up on what's happening with the trial yesterday. Bring everybody up to speed. The trial should start at the top of the hour, but they've usually been starting 5-10 minutes later. Yesterday, Law and Crime didn't start their stream until 20 after, and they started right in the middle of arguments. So it took us a while to figure out what the hell was going on. But that's Law and Crime for you. We will be joined by the usual, the ever lovely, the ever talkative and wonderful companion here for Aussie Overlaw'd. Aussie Overlaw'd and I, Chandler Remington, will be showing up here in just a little bit. We just finished our O.J. Simpson stream, and now we're coming on over here to do this. She's probably getting prepared for the long haul we're involved with today. I'm just bringing up the Law and Crime thing here now. All right. That's locked and loaded for when they start streaming. So, wow. Yesterday, like, I'm assuming that everybody here knows the basics of this trial. We've got 627 of you here, only 260 likes. Shame on you people. Like 2/3 of you aren't doing your job, or well, about half of you aren't doing your job. I'll be generous. So get down there and hit that like button. Let's get us on the YouTube algorithm. Let's pray to the algorithm gods and get us noticed and get people recommended here. And while you're at it, I would be deeply honored if you would hit that subscribe button, because we're pushing our way to 36,000 on our journey to 50,000. Right now, we've got 35,546. So that's just about 454 we need to get us up to 36,000. I would deeply appreciate it. And just for shits and giggles, we have a like and subscribe poll that we look at every day. We make a witty little poll to remind you to hit the subscribe and like button. Today's is kind of lame because they always are. I hit the like and subscribe button so the DA will stop yelling at me. I hit the like and subscribe button, so there will at least be some DNA. I hit the like and subscribe button, hoping to find an orange in my robe. if you don't get that reference, Judge Schroeder yesterday found an orange in his little man bag there that he keeps near his robes, and he was really happy about finding that orange. And I hit the like and subscribe button. Objection asked and answered. I just about ended the poll. That would have been the boomer moment. But all right, that's our like and subscribe poll. It's for fun. Go take it, enjoy it, and we'll check back just about the time trial starts, and then every hour we'll take a look at it to see how the poll is coming along. And Brad Best, B3ST, member 5 months of the Clean and Sober crew. Thank you, Brad, for that. He said, hello from Edmonton, Alberta. Thanks for the entertainment every morning. Well, you're very welcome. That's what I'm here for. Are you not entertained? Mighty Meat, hey, what's up? And we looks like we got most of the people from the OJ Simpson stream over here. All right. So with all that housekeeping stuff out of the way, just wanted you to know that super chats are not required to communicate with me. I do my best to read some of the important comments in chat, and if I catch them quick enough and if they're relevant enough, I'll highlight it. But I am reading as we go. I try to read as much as possible. We address a few of them. But if you're parting with your hard-earned money to give me anything, well, the 99-cent stickers up to a $500 super chat, whatever you do, I gratefully and graciously accept it as a donation to the channel, and that guarantees you that I will read your comment because that I owe you at least that much for your participation and your support. So not required, but gratefully accepted if given, and it gets you your comment read, responded to, whatever, no matter what it is, unless it's something that'll get me deplatformed. Gigi Beauchamp Bright, new member. You are a new member of what? Of the Clean and Sober crew. Thank you for joining the membership. That is very, very, very kind of you. All right, welcome. With that, again, for about the fourth time, Flux bringing our super chat, the very first super chat of the day. Panzer Prison. Jeff, this trial is a shit show. How do you keep promising murder cases, yet murder seems to be far from these cases? Yeah, we've got this case has become a missing person case, and they're trying to make it a drug case. We'll see how close they can get to doing that. But this trial was supposed to end tomorrow. And as we all know, that ain't happening. There is no way that's going to happen because Flux, League of Vices, read my super chat. I just did. Calm down. You know that, Flux. Yay. See? There you go. Yeah, the prosecution doesn't even look like they're anywhere near resting their case. So the defense hasn't even started. So we've probably got another, assuming they're ready to wrap this up soon. I don't know how they can be because they haven't even talked about the murder yet. There's still, most of the witnesses have been designed to get the pictures that have been taken into evidence and to say that the guy seems to be dead because nobody's heard from him in a while. We'll just have to see how it goes. American Dreamer says, good morning, Jeff. Well, good morning, American Dreamer. And I wish I was drunk. How are we, chat? And Jeff, hope all is well. All is great today. It's a great Thursday night here, and we're one day away from Friday. And what's going to happen, just to kind of give you a little future view here. Tomorrow, Friday, we'll do this stream as usual. I'll get to sleep. I will wake up early Saturday morning here, my time, which will be Friday night, your time. And then I'm going to jump on a train to Seoul. I live here in Korea, in case you didn't know, and I'm going to go up to spend the weekend, Friday night, out drinking and carousing in Seoul with Andrew Legal Mindset. We're going to tear up Seoul a little bit, and then I'll come back and take a break on Sunday. Ordinarily on Mondays, I do a Maritime Monday show, but I won't be able to do that this week. Next week, because I've got something coming up on Monday. I don't know if I'll delay it a day or just wait till the next week. We'll have to see how I feel at that point in time. So what happened yesterday? Oh my God, what didn't happen yesterday? There was a lot of argument back and forth with the judge and both sides. In the morning session, Judge Schroeder was getting a little bit hangry, it seemed. he was quite perturbed by both the defense and the prosecution. There was a chunk where the defense lawyer kind of took the brunt of his anger. And there's so much hearsay. They're arguing about whether to let things in. They're questioning whether to have mistrials again. It was a pretty hectic morning. There was probably a ratio of maybe 60% sidebar out of the presence of the jury stuff and 40% trial. And the trial that was presented was that nobody's seen the guy. There's been nothing. Gutierrez, the allegedly deceased person. That's where most of the testimony was driving at, was that nobody's seen him. And the judge, they wanted to get in some hearsay. The prosecution wanted to get in some hearsay, but the defense objected, saying, well, it's triple hearsay because it's something that Mr. Gutierrez told somebody who talked to somebody else. So it's triple hearsay. And the prosecution said, well, the guy's dead, so we can't do this. And the judge stepped in and essentially said, well, how do you know he's dead? We don't have a body. You've got to prove that you've tried to subpoena him. You've tried and you've failed. He's unable to be located. You've got to lay the foundation for this. You've got to show you did this. And that kind of took the prosecution by surprise. And he was saying, well, I thought, because nobody's heard from him, we just assumed he was dead. And he said, well, don't make that assumption. And so there was this huge battle about the triple hearsay. Gosh, we had the triple hearsay argument. And then there was the creepy friends of Gutierrez that they heard from Gutierrez's boss that he hadn't showed up, because they had some little Facebook group where everybody was there, and she mentioned something like, if you've seen him, and then somebody put up this notice that if you hear anything from him, call the police. And so these two friends, they decided that they were going to be Facebook warriors. So they made the 40-minute trip to the town just to find out what was going on. So they searched Google, they talked to people, they looked at things, and they found the address for Zachariah Anderson. And they were led by one of the witnesses, I believe it was the boss, I can't remember, that that the defendant apparently broke into the allegedly deceased guy's car, and there were some problems. And so and someone else said they thought he had something to do with the disappearance. So they went to confront him. And these two guys basically went around to Zachariah Anderson's backyard and confronted him in the backyard. Like, are you Zachariah Anderson? We came to talk to you. We heard you have something to do with our friend's disappearance. And he's like, hey, dude, I don't know who you are. I'm not Zachariah Anderson. Get the hell off my property. And the defendant then called 911 and reported that these people were kind of creeping him out by doing creepy stuff. And then they had another witness on where she was the same way. She testified that, she knew people. And so then she started doing all this keyboard warriors. Oh, and then these two creepy guys, they went to the ex-girlfriend, to Sadie, who's in the center of all of this. They went to her house to talk to her about it as well, but she wasn't there. So they just kind of snooped around the property to see what they could see. And then another lady testified that she was a keyboard warrior, and she went to investigate all these things by herself. It was just really, really weird. And the afternoon session did not get any better. The real question is whether Schroeder's orange is too angry to be appealing. Not enough blood. Oh, there's not enough blood. Well, that was one of the things when they were talking about assuming that he was dead. The prosecution referred to the huge amount of blood that was at the scene, and whether, that should just be proof enough he couldn't survive. And the judge is like, I don't know about that. So in the afternoon, What are the odds crazy clerk lady? Yeah, crazy clerk ladies from 2 days ago. What are the odds crazy clerk lady has the missing guy tied up in her basement? GPS snapshot. Uh, that's a reasonable doubt. I mean, she very well could, because they're certainly not pinning the murder on this guy. They tried yesterday. And they're probably going to get to what is their only direct evidence today. And well, I'm sorry, it's not even direct evidence. Their strongest circumstantial evidence today. But we've got to get there first. Oh yeah, women need to stop with their true crime addiction, and so do guys. It was, two other guys were doing it. Yeah, see, there's enough blood if he was a 12-year-old. Let's just forget Murdoch ever happened, because that was such a farce. Jeff definitely has a puppy cam in his living room, so he should stream that. I do, but it's like ancient. And also my dogs are always in here. Strawberry always sleeps on that chair or the other chair, and Yoda always sleeps on the living room sofa when he's done in here. And I don't see him around. So, all right, what happened in the afternoon session? After lunch, they came back, and there was a woman that testified for some reason that I can't put my finger on. Then what happened after that was a crime lab guy, Ronald Witucky or Witucky. They pronounced that several different ways. He worked for the state crime lab. He analyzed if you remember, a couple of days ago, there was one of the crime lab ladies that testified that she analyzed the evidence. He analyzed her analysis. He did peer review of her record to make sure that it was based in science and whatnot, and it was acceptable, and her conclusions were supported by her report. One of the things that he did, which was just weird, it was a lot like the Murdoch trial. I know I said let's keep Murdoch out of it, but now I have to bring him up. It's how the prosecution in the Murdoch trial presented all of this evidence. They brought out many, many, many guns, and their conclusion was these guns had nothing to do with it. They brought out magazines, and these the magazines will hold bullets, not like Playboy. Odd that was the first magazine that came to my mind, but they brought out magazine after magazine. No, these had nothing to do with it. They brought out shell casings. These had nothing to do with it. This was the same thing. The first thing that he testified that he peer reviewed was the finding that the defendant's jeans, that Mr. Zachariah Anderson's denim jeans, were tested, and his DNA was on his own jeans. There was a lot of testimony about the defendant's DNA being on the defendant's jeans. Nobody else's DNA were on the defendant's jeans, but the defendant's DNA was on the defendant's jeans. So there you go. No, Eric, that's not what happened. Then he testified about blood on the door, the ceiling, and at the crime scene. It doesn't have to be a murder scene; it's a crime scene. He testified about blood on the door, blood on the ceiling, the tabletop, and he said he compared it with 7 other people. They did like a pool of 7 people, and they came to the conclusion that the blood all over the missing person's house was from the missing person, Mr. Gutierrez. So yeah, all the blood in, and by all, I just mean what was there. I mean, I don't think it was that much really, but what do I know? All of the blood at Gutierrez's house was Gutierrez's blood. Well, congratulations. We've proved that the missing guy's blood is in the house of the missing guy, and that the defendant's DNA is on the defendant's jeans. Well, that turned to the tiny, tiny speck of DNA that was found in the back of the defendant's vehicle. Now, if you've been watching this from the early stages, they said that the defendant broke into Gutierrez's car. And the defense asserts that in retribution, revenge for that Gutierrez broke into the defendant's car. So they think they may be able to explain away this little spot of DNA, but this little spot of DNA, they refer to it as a speck or a pinprick of DNA evidence. And he talked about that. And I mean, there was a good hour argument. it was a good solid hour of argument about that. And the previous crime scene investigator, she said that they couldn't test it for blood because it was too small. They could test it for DNA, and it was DNA from a single source, and that single source was male. And then at the end, the prosecution asked her, well, in your opinion, looking at that stain, even though it wasn't tested, is it what is it? And she said, well, with a degree of medical certainty or scientific certainty, I believe it's my conclusion it was blood. There was no test to determine if it actually was blood or not blood. But she said that just by looking at it and knowing what she knows and her expertise, she believes it was blood. And before we finish up this little line of questioning, we get to bring up Chandler Remington.
Hello. Good morning, everybody.
Oh, you've changed your costume.
I did. Well, I saw that somebody was like, is Chandler wearing pajamas this morning? And I wasn't, but I could see how it kind of looked like pajamas. So I'm still wearing red.
That was an awesome silk dress. It was awesome.
Oh, thank you. It's like sort of a tunic-y kind of top. It's one of my favorites.
I loved it. So whatever. Don't listen. Don't read the chat. They're all degenerates. All 1,095 of you that are here.
Well, it's too late now, so let's do this.
It's too late, baby. Now it's too late. All right. We're talking about the crime scene investigator guy that was peer reviewing the previous CSI's report.
Yes.
And he looked like some guy that would peer review other people's reports. But anyway, so the previous lady, she didn't test it for blood because it was too small and would have destroyed it. But she said that it was her conclusion with a degree of scientific certainty that it was probably blood. And they wanted this crime scene investigator peer reviewer guy to confirm that was a reasonable conclusion, and he would not do it because that wasn't in the report. It wasn't in her report that it was blood. And he said, I can't peer review that because it wasn't in the report. And they kept pressing him. And he really did not want to lie and say that it was blood. And all he would say was that DNA was detected and it wasn't semen, it wasn't hair, and it wasn't spit. Said it could have been skin cells, but not likely. But he wouldn't say it was blood. So kudos to him for being an honest prosecution witness.
I guess my question is, what else is there? My idea was touch DNA. It sounds like touch DNA to me.
Well, he talked about touch DNA, but he said it's unlikely because that's not a good source of DNA. He said it's unlikely to be touch DNA, which was the skin cells. He said, that would be touch DNA, and that's not a good source of DNA.
So there was a tiny little fleck of what could have been blood, but maybe wasn't. And this was in the car. Is that what we were discussing?
In the defendant's car, yeah.
Right.
In the very back, a little teeny tiny speck the size of a pinprick. So again, kudos to him for not just fudging it and carrying out along the prosecution's line. Could have been a booger. Yeah, you're right, Pond Walton. Yeah. Could be. But we'll have to see if the defense goes through with their statement that they said they can prove that the allegedly deceased Mr. Gutierrez broke into the defendant's car. We'll have to see if they can prove that.
Well, that would be an interesting point. I mean, it was kind of a tit for tat situation. Zachariah Anderson had broken into his car, and it seems as though he might have had it out for Mr. Anderson. So I don't know exactly if that helps or hurts the defense, but.
Well, allegedly they have cell phone GPS data putting Gutierrez at Zachariah Anderson's house. We'll have to see if they go through with that. Was it the murder victim's DNA? they would only say that he wasn't excluded, if I recall correctly. It didn't exclude him. It excluded other people, but it didn't exclude him. But it was a single source male DNA, meaning there wasn't other people's DNA mixed with it. We'll just have to see how that goes.
That doesn't inspire a lot of confidence in me personally that it was his DNA necessarily.
Yeah. Well, the next witness was a Ms. Washington. Sorry, that was the prison snitch guy. It was a Ms. Remsburg. There are so many ex-girlfriends in this case.
Yes, I think Christine Remsburg is Zachariah Anderson's ex-girlfriend.
Yep. And this is like the second or third ex-girlfriend of his that's testified. Mr. Gutierrez, he's had a couple ex-girlfriends testify, one of whom was trying to be his new ex-girlfriend by hooking up with him on the night that he disappeared. Everybody's got, and we have ex-girlfriends of other witnesses on the stand, but this was Zachariah Anderson's ex-girlfriend's sister.
I see. Another Remsburg. Christine Remsburg was the ex-girlfriend, and her sister.
Yeah.
I don't presume you know her first name, but she was so Christine Remsburg's sister. Okay.
And I saw it, and I guess you probably saw it too with Aussie Overlaw'd, unless you weren't there.
I was there. I had a bit of tequila, so I had to leave the stream at a certain point. I had some stuff to do yesterday, so I actually think that I missed Ms. Remsburg's testimony.
All right, we're approaching. Well, it is now the time that court is supposed to start, so we'll share the screen so we're ready when it does happen, which is usually about 10 minutes from now.
Yeah, they're pretty late usually.
Yeah. All right, where is
my pet peeve is when they start the stream late and they've already been discussing something and we miss the context for it. It's a little annoying.
Yeah, that's like happened yesterday. So we'll keep this down here so I can look at it, and then when they go live, we'll bring it up. Legal advice is has the victim been declared legally dead? If not, how is he charged with murder? I don't think he has been.
No, I don't think that he has been either. And the reason
just in context, I'm
going to say no. And my reasoning is that in the opening statement, the DA would have said it. Instead, he said that he was essentially dead to everybody who knew him. If he had been declared legally dead, they would have hammered on that. So I don't think he has been declared legally dead.
He's not totally dead. He's just mostly dead.
And so how is he charged with murder? That's a very good question. I mean, the guy disappeared. He didn't contact his mom. He didn't contact his kids. He didn't use any of his credit cards or any of his money. There's no trace of him after that. I just don't think there was enough blood at the scene to really convince me that there was a murder there. So that's the problem that I'm personally having. I don't know how they're charging this guy with murder. Maybe assault, maybe attempted murder, but without a body,
it makes it extremely difficult. Yeah. And as I was saying before you came on, the vast majority of witnesses have just been on the stand to say nobody's heard from him.
Yep. Pretty much.
There's been a couple of people that say they heard that the defendant had something to do with it, and they went to check him out by being Facebook and Google warriors. But nobody's really shown any direct evidence yet. We're going to probably get to serious, substantial evidence today. But that was the Remsburg. The only thing I got out of that was that her sister dated and had movie nights with Zachariah Anderson, and then he drove her Audi car on occasion.
Audi, yeah.
Yeah, the way the DA, he pronounces Audi as like Audi, and it just drives me up a damn wall. And again, yes, he may be dead. If all these people can prove he's dead, that still does not prove the defendant did it. And weirdly, I was reading Law and Crimes chat while I was rewatching it today, and some of them are starting to come around. They're starting, and Law and Crime people are so far up the prosecution's ass 95% of the time. And a lot of them are now saying, why is this guy on trial? This doesn't prove it.
Really?
They're still the diehard, true crime wine box moms that are all the prosecution is always right group.
That's kind of big. I feel like I wouldn't have expected that. And they've been very, very pro prosecution up until this point.
Now, where we left off with this was the last witness. The last witness was a Mr. Washington who was in prison, who was a cellmate of Mr. Anderson. He's a prison snitch. He is on the stand to testify eventually, maybe, that Zachariah Anderson confessed to him that he stabbed the defendant. I mean, he stabbed he stabbed Mr. Gutierrez.
Yeah, it was a very convenient confession.
Even though all evidence points to the fact it was blunt force trauma and not a stab wound. But what we got through with the prison snitch was that he was in prison for federal drug trafficking charges. And I mean drug trafficking charges. I can't remember what it was, but I believe it was 600 pounds of marijuana and 50 kilos of cocaine.
Yeah, he was a heavy hitter.
Like an absolute fuck ton of drugs.
Yep.
And he gave details of his plea agreement, where he has been promised a reduced sentence if he tells the truth and rats out Zachariah Anderson.
Yeah, this is a man who has a history of witness intimidation for his own charges in previous cases. He has been known to intimidate witnesses who were going to testify against him at trial for his own charges. So the way that the defense presented it, and I agree with this, is that this is a man who is willing to do anything to get a reduced sentence. He will save his own ass no matter what. Now, he was only a cellmate with him for like 3 weeks, I think.
Yeah, like 3.5 weeks. And this is a guy that hasn't said anything to anybody for almost 3 years. But now suddenly he just starts confessing. What do we got going on here? I guess these are the guys that screw up the audio for us every day. How cool is that? We haven't seen the guys that screw up the audio.
Oh, there they are. Those motherfuckers.
Wow. Huh. Interesting. All right. Well, we'll keep them out here for a bit. Well, that means the court may be starting soon. So we'll get through all the important stuff and then we'll go back and talk. So yeah, 50 kilos of cocaine and 600 pounds of marijuana, facing a lot of time. They're going to give him a deal if he tells the truth about this. I mean, I said Zachariah was quiet for a damn long time since was it 2020, but suddenly you put him in a cell with a complete stranger for 3 weeks and he's like, hey, let me tell you how I did it. Mm-hmm.
They became fast friends. I think somebody in the chat said it was 5 weeks. It's there.
Oh, yeah, it was 5 weeks and he confessed after 3.5 weeks. That's what it was.
That is a big difference.
Yeah. And he testified about how he bartered with Zachariah Anderson for cans of tuna fish. And he said relevant. He said that the defendant Anderson was paranoid and saying that the government police were planting evidence and putting informants in his cell. Well, fuck, maybe he wasn't. It looks like he wasn't paranoid after all, because there was a rat in his cell, alleged rat. And then they got in a big argument about what he can say and what he can't say. And the defense has made a motion to throw out all of this guy's testimony because he's clearly going to lie and say whatever it takes to get a reduced sentence, whether it's true or not. And the judge gave them until 10:30 local time last night to brief it up and provide case law and whether or not, because they want to bring in all this drug activity to bolster the guy's credibility as a witness. They want to show all these drug things that that this snitch did, so they can say, see, look, he's a bad guy and he's telling you all the bad stuff he's doing, so he's telling you the truth. And so they're going to argue about that a little bit this morning, and the judge will decide whether or not to throw out all of that testimony. That's what I said. They to exclude the drug testimony. And so that's what they're going to argue about. And that brings us up to the point where we got to burn through some super chats.
Let's do it.
Wow. Yeah, not everything, just the drug case. That's what I mean. Everything up to that point dealing with drugs. Sorry, that's what I meant to say. And all the stuff they want to put in. They don't want to go down that path. Anywho, super chats and other things that I've highlighted from the beginning. I hope I have enough popcorn for today's shit show, says Chaos Coordinator.
Yeah, make a
Should've
big
made some
bowl.
popcorn. Oh, well. Oh, shit. I guess we're getting ready to start. Dang it, I got 17 more of these things through. Wolfram says missing murder weapons, missing body, missing fingerprints, missing DNA, thus missing murder. I have to agree with you. And there's no DNA here or there. There's none of the defendants at the murder scene, none of the murders with the defendants, except for that little bit. Do not read this. Failed. Too late. I failed. Oh, you got me. The real question is whether Schroeder's orange is too angry to be appealing. I hope it was fresh. He looked happy to find it, though. Mangs says, what are the odds crazy clerk lady had the missing guy tied up in her basement? And it's very, very good odds. Doral On says, thanks for the summaries. I can't stay for the whole stream. And Denny sounds like BS. Argue it isn't. Oh, I'll bring this up during a break. Denny's an important thing. The Denny rule is an important thing. Maybe we should have a whole stream on Denny.
Are they continuing to bring up Denny stuff right now?
No, I think it was just him saying that.
Got it.
What have we done here? Thanks for tuning in. Stream ended 21 seconds ago. Congratulations.
Excuse me?
All right. Law and crime has boomered themselves, apparently.
Clearly.
They've given us the we got to get rid of this here.
And that's a wrap.
Thanks for tuning in. Stream ended 21 seconds ago.
Yeah, we forgot to film it, but Rosalio Gutierrez walked into the court and he was like, dismiss the case. And Schroeder was like, all right.
Oh, wow. They've rescheduled it for 12:30 a.m. it looks like.
Weird.
That's the latest they've ever really started. So, all right.
I'm confused.
Yeah, well, aren't we all? All right. Lol. When you send a message, I'm not going to send a message to Lon Cuck. Hello again. Let's see what they're saying here in Law and Crime Land. We don't get to see the lawyers right before the jury is supposed to show up. Why? Welcome back, everybody. Fight. All right. We'll see we'll see what they're saying a little bit later. We don't care about them right now. Now now we can slow down and talk about things a little less furiously.
Sure.
Volpe Fox says, did we find out why GPS chick was 40 minutes late showing up to the building? Nope. And we don't even really know if she showed up to the wrong building. She just said she showed up to the wrong building. That's an odd thing for me. What's her alibi? Well, she doesn't need an alibi because she's not charged with anything. And I don't think they asked her for an explanation. I'd like an explanation. Didn't.
I don't think defense asked her for an explanation. I think the only evidence that she showed up to the wrong building was the DA saying that he had met her at the location and he went to the right location and she was at the wrong location and said, I'm here.
Yeah.
So.
And then she took him to the other place and that made him a witness in the case because he's an idiot.
Yeah.
So we don't know why.
Recused. He wasn't recused even though he is a witness. He was only excluded from questioning her because he had something to do with that particular witness.
And for all we know, they could have met on time because they were planning to drive around, meet and drive around and talk, or at least that's what she said, because it was their first meeting. So he could have gotten her car. She could have taken him somewhere, stabbed him repeatedly, or went into the house and beat the shit out of him or something, or somehow got rid of him, and then threw him in her car, drove away, dumped the body somewhere between there and Milwaukee, and her car could be saturated with blood and DNA evidence from Mr. Gutierrez, but we'll never know because the cops didn't find out. And that's what the defense lawyers were harping on during the opening statement.
Right. And I find it really hard to believe that if you would the implication is that he transported this body in his vehicle and then he cut the carpet out of the back. I have a really hard time believing that there's just one tiny speck of maybe blood in the car if he's transporting this guy's body. I don't think he's that put together. He's not like Breaking Bad level, body disposal. So.
And Michelle, well, thank you for deigning us with your presence today. Happy Thirsty Thursday. Happy Thursday to you all the way in South Africa. Blue Varo, at least Playgirl wasn't the first magazine that came to your mind. That's true. Odd that was the first one you thought of when you were going to send that message, but okay. Resist Impulse. You look great, Remy. Focus on LSAT, not chat. Everybody needs a break.
Well, I like feedback from the chat because my audio can be a little dodgy, and so some people are like, "You're too loud, you're too quiet." So I like to pay attention. Just I like good feedback. I thrive on feedback. So, but Elsa, yeah, I'm definitely that is I do have my sights set on that. Thank you for the super chat.
Do it. You'll do great. Just take all the study courses you possibly can and practice test. Focus on the game section.
Oh yeah, I have a big book of them. Analytical reasoning is really my weakness. That's something that I'm trying to work on over the next couple of days. But I think I'll get there.
And focus on the books that teach you how to solve the puzzles, like the strategies and what to explain. Anyway, you know what to do. You're smart.
I took symbolic logic in college, but that was 5 years ago. So I'm trying to remember some of those formulas. It was one of my favorite classes, and it definitely helped me study. So I'm gonna try and see if I can eke out some of that knowledge from somewhere in my brain.
I would. Yeah. Oh.
Judge is back.
And
yep. Dang it.
I did.
We still got 7 to get through. Rick Nikita, he's a Star Trek fan and beautiful. She's a Star Trek fan and beautiful. Oh my.
Aww. Thank you.
Who had the floor?
I do love Star Trek.
Resist impulse. We know that we know about DNA. Explain why Denny isn't total BS. And we got to talk.
That'll
about
take
that
time later.
Matthew Self, legal advice. Did you get my email with the StreamYard overlay with the cage? I did. I just didn't have time to put it up.
I don't think anyone really had the floor the last time we left, Judge. It was simply
Wolfram, hey,
the state
Brenda did not kill Chandler after all. That's very good.
Send over cases. We've received the cases, reviewed them.
I'm alive.
Really, I guess it's up to the court.
3 more. And
who you'd like to hear from first.
David Edwards, what, if anything, can I say to make you say what I want you to say? And Resist Impulse, if you look at actual innocence cases, they always have a jailhouse snitch. Yep. Jailhouse snitches are the worst of the worst.
The first thing I want to make clear is that I hope the court will draw a distinction between 2 types of evidence Marquand Washington provides on this general topic of drug activity. One thing that Mr. Washington has provided to law enforcement and disclosed in a report provided to the defense is that the bonding between these 2 individuals occurred over drug dealing, that both of them recounted their activities with prior drugs. And I believe that in regards to the defendant here to be marijuana. So the defendant is purported to have said to Mr. Washington that he had connections in Detroit and California, and that he used to transport hundreds of pounds.
All right, everybody, how's the audio balance between us and the court? Say something, Chandler.
That would be historical information, which would be the defendant's
Say hi.
side of the report.
Oh, hi. Sorry.
I was also
how's our audio?
Activities with him. That's how we came to sort of trust each other and reveal details to each other. So we didn't just bond over I think it was tuna that he said was the other way that they bonded, but because they were discussing mutual past activities. So that is one thing that I'm asking the court to allow. I do think there's some distinction between then what he reported about the direct circumstances that are revealed in this case. So this investigation, right? So things that are contemporary.
All right, I boosted the court significantly.
And Marquand Wash, and from the state's perspective, those things reveal to a jury that Marquand Washington has inside information.
Apparently that's not enough, so I boosted it again.
Confidence being expressed, right? So it makes his details about any confession more believable because he has details about other circumstances of this investigation that would not be readily available. Okay, so those details are that the defendant had caught a case going back and forth from California, but not worried about it because there's not much, because it wasn't that much. So we know that the defendant had a pending case in South Dakota where he had transported pounds of marijuana from the West Coast. But it wasn't substantial, it wasn't hundreds of pounds, it wasn't even dozens of pounds of marijuana. So from this, I think it's 10 pounds, right? Oh, apologize. Well, it is an amount of marijuana that would, in the context of people talking about hundreds of pounds, would not be as significant. And I have I can tell the court what it is. But anyway, and as the court
Nope,
knows,
haven't boosted me.
Defense
StreamYard
Burns
does their
already
stupid thing, and it
testified. I
pisses me off. I'm
accompanied
going
him
to
South Dakota
quickly
Now,
refresh
Mark Washington
the
doesn't
law
know
and
it's
crime
from
stream.
South Dakota. Doesn't know it's from South Dakota. He just knows he caught a
There.
case. And
This
in
might help, it might
perspective,
not.
It's, not a major deal. Again, it reveals a confidence, right? Reveals something that is not that's not available, for instance, in the criminal complaint, where it indicates he's been convicted of a case but doesn't provide any of the details about that. Then there's the piece about what
No change. All right, we'll turn us down.
Raid of the defendant's home. Okay, so what Mark Washington says is the defendant told me the police raided my home and they got a lot of money but a little weed. Okay, and of course, what's found in this raid by the police search warrant search is 2 pounds of marijuana. It's the seeds the court saw in the picture on the that's in evidence, and more than $47,000 in cash. None of those details are in the criminal complaint. None of them, and I'm not aware of them being in any coverage that I have seen of this case. In other words, what was specifically obtained in that search warrant. We didn't charge the drugs, right? So it wouldn't logically be a part of our criminal complaint. But the $47,000 is also not in the criminal complaint. So Mark Washington knows that fact without it being in the criminal complaint. And from the state's perspective, that provides me an opportunity to argue to this jury based on things that are in this investigation, not separate and distinct drug, cases, not a month ago, a year ago, whatever. It allows me to show that he has some credibility in having heard some confidence from the defendant.
All right, I've pulled my volume down.
You might say to yourself that a person might get to a point where they might go as far as admitting some complicity in a homicide.
Oh, and as soon as I pull my volume down, they boost the court. I'm giving
So I'm going to suggest first that the state's decision-making in this case was really defined by the case State v. Dukes, which is one of the cases I submitted. And I think that the legal phrase that you hear nowadays is called panorama evidence. And I don't commonly use that phrase, but I understand it to be, as defined in Dukes and as I thought about this case, that you don't need another Acts motion if you are describing circumstances and conduct, and I'm including criminal conduct, that is being used to explain items that are of interest to a jury and would be important for a jury to understand. And so in the Dukes case, as the court knows, the prosecutor did not file another Acts motion. The prosecutor is introducing evidence of activities that were happening around a house that police believe is a drug house during the time period of around May 27th. The criminal case itself is about a search warrant that occurred on June 26th, so a month later. The defense very strenuously argues this absolutely should be another act. It's other bad conduct that you're alleging at this residence and connected to our defendant, and you are using this to show that he's in conformity with the same activity. In this
sounds reasonable to me.
It has some similarity in conduct, so it's probably even more something that would be at least on its very surface the kind of thing that you would think might be other acts, right? Because it would be an identity type of thought process in terms of another acts analysis. But the court in that published decision, of course, the Court of Appeals, it indicates very strongly that they do not believe this to be other acts evidence. They don't do that based on the similarity. That's not their analysis. It's not analysis based on 90404. In fact, they reject 90404 being the criteria that you would use. Now, obviously, they do an analysis about whether it's unduly prejudicial, right? So, and I invite the court to do that in this case and to think about whether drug activity is something that's unduly prejudicial in a murder case, and whether there's any propensity sort of worries about that, and whether a limiting instruction, as is recommended in all the cases I cited to the court, is a appropriate and strong and considered a definitely helpful remedy in terms of any misinterpretation or misuse by a jury. Obviously, the state's aware it's limited in its ability to argue that and understands that we can't do that. But in Dukes, paragraph 31, from the state's perspective, is the crux of the case in terms of talking about all of that, and in terms of talking about whether, finally, it's unfairly prejudicial. It defines in paragraph 31, unfair prejudice arises either when the evidence submitted has a tendency to influence the outcome of jury deliberations by the use of improper means, or when it arouses in a jury a sense of horror or desire to punish. Now, I just don't think the marijuana business is such that is, at this point, a factor, particularly in a homicide case with these egregious set of facts, with the pictures of blood that these jurors have seen. And then it goes on to describe the evidence that is outlined in this case and why they believe that it is essentially panorama evidence. They say the evidence presented by Carter, that's the detective, informed the jury of police surveillance at the residence, that the behavior they had observed was consistent with the operations of a drug house, and that they searched a car because they suspected it contained drugs purchased. And from that address, and their suspicions were confirmed. So what it does is it ties together why people did each of the things they did. It ties together why officers were appropriately making decisions they were at each of those stages. And it is used to bolster the particular allegation that the defendant, in this case, possessed drugs with intent to deliver at a location when the search warrant was found. Now, the things I've talked about are not actually direct. It is a case that stands for the proposition that for collateral but important purposes that meet an appropriate definition of relevancy, that the court can admit this panorama evidence without utilizing another acts analysis. And that's where that's where I was. I do want to talk about the question of other acts briefly, because the court certainly, before I cited these cases, was strongly inclined towards another acts analysis here. So I want to acknowledge that, and I want to talk about the cases that I think support admission of this evidence when the court considers the factors that are relevant in Sullivan. The case of Plymesser, court sexual assault case, right, 1992, talks about an ability to use other acts evidence to corroborate a victim's testimony. It's victim in that case, but really it is the reporting witness. It's to bolster a crucial witness to the state. It's to bolster and corroborate their testimony. So when I talked about a line of cases, that Plymesser case is an early manifestation of that particular situation. But the Dorsey case, and then I think even more particularly the Hunt case, also adopt that. The Dorsey case that I talked about is also another acts admission. And they're not just talking about a victim. They use language in Dorsey about the bolstering a witness's credibility. They say in paragraph 49 of State v. Dorsey, furthermore, to the extent that our case testimony operated to bolster CB's credibility, we have held that, this is in quotation mark, a witness's credibility is always consequential within the meaning of Wisconsin statute 90401. So the court knows that 90401 is relevancy, right? So I'm going to suggest to the court that when considering this analysis of whether these things are relevant, State v. Dorsey, which is a state Supreme Court case. Yeah, I'm sorry, it's paragraph 49 and then into 50. So that what I just read, what I just quoted is paragraph 50. I apologize, counsel. So this is a 2018 state Supreme Court case which defines a witness's credibility as always being consequential, which is one of the ways you define relevancy. So in this case, we have two witnesses whose credibility will be absolutely attacked in this case, and they're key cornerstones of the state's case. One is Marquand Washington. The jury issue here is he credible for any purposes that the jury can get a grasp on?
I don't think he is.
Reporting this individual confessed to me. Is he credible? And the evidence we're asking to introduce bolsters his credibility, which is endorsed by Hunt, Plymesser, and Dorsey in terms of in general. And Dorsey, the state Supreme Court, clearly said that if that is the case, it's relevant.
Well, I'm sorry to interrupt.
Okay, that's okay.
But
I'm not sorry you interrupted.
As I was yesterday, was with you've got a individual who is accused of multiple crimes, who has made some kind of a plea bargain with the government to cop a plea to some lesser charges, and one of the ingredients in the deal is he's got to testify in this case. And so we know on the one side there is an enormous incentive for him to come up with something. And I'm certainly not suggesting there aren't many people under those circumstances who follow through and testify truthfully, and the government got a good bargain. And I'm not suggesting that the government shouldn't be in that kind of arrangement, making those kind of arrangements with people. But in the end, you're asking me to find this jail inmate is more believable because more reliable because the defendant allegedly made some admissions to him about a crime that has nothing to do with what is an issue in this case. And I'm thinking, well, now, step out of the role of the DA for a minute. If you're looking around for a car and you stop at two different car lots and find vehicles that are substantially identical at the same price, and you know that one of the offerees is sitting in jail under circumstances such as this witness, are you going to consider him more believable because he's taken a deal to testify against somebody else on an uninvolved matter? You're going to consider him as the more believable of the two people you're dealing with? I'm not at your destination point.
Yeah, I'm certainly not, right? That is a valid argument, and it makes perfect sense as an argument about his credibility, and I'm certain the defense will cross vigorously on that and make a vigorous argument, and they should, right?
And it's a jury issue, and it's not for me to make.
And right,
the problem
and
it comes at a price.
Right. So Judge,
introducing evidence that this man has committed a crime totally uninvolved with the crime charged in this case. That is specifically barred by statute, except in limited other instances. Go ahead now.
Yeah, so I think the court has very articulately expressed why, what the compelling argument is about whether he's believable, and I am indicating that the appropriate ability to argue that there are elements of believability. The court's watched.
There are elements of believability.
Yourself, the way you bolster the credibility of an individual who certainly would be questionable in those ways, a co-defendant who testifies against someone, those kind of things, right? Is you show specific information that they would not know unless the things they were reporting as true, right?
Well,
so that drug raid I'm talking about is a example of that, right? So just so we're on the same page.
Don't say right.
And also, if it's a person who's not intimately connected to you already, right, then I think it's a valid argument for the defense to say, well, this guy's living with him for only 5 weeks. The inmate himself, Mr. Washington himself, says this guy was paranoid. He thought people were bugging his cell and things like that. He's not going to admit to this guy that he committed a homicide. What possible reason would a jury have to believe that? I think that's a very valid argument by the defense, right? And the reality is we have information that is offered by the inmate that this other activity that they mutually discussed is the reason that those barriers, yesterday I said it was the icebreaker. So I respect and believe that all those arguments we just described, including the one you articulated, are totally appropriate. And the truth about how that could be answered, right? Considering that Mark One Washington may simply be telling the truth, Judge, right? Considering that this man might simply be telling the truth, to give the jury a chance to consider that based on the information
don't do it.
We would be having this discussion, right? So, and in the Hunt case, which is the last case I want to mention about this, they talk about that other acts in this case. So this is another acts analysis, again, respecting the court's discussion yesterday afternoon. The other acts in that situation are provided necessary background and to provide an independent source as to, in that case, the victim or the witness's credibility. So again, it's about the victim or the witness being someone whose credibility can be assessed by a jury. Jury doesn't know. In that case, the witness involved was recanting, right? So the question is, was their original discussion credible? And it is the other acts are admitted, and the question the question there is, can we use this for the very specific 90404 sub 2 purpose, not delineated in the statute, but where it says or other means, right? Is to bolster, in that case, a victim and a witness's credibility. So here we have, I want to mention the one last piece in terms of a witness, and that is the daughter in this case. So she has just turned 12, just a few weeks past her 12th birthday when she speaks to law enforcement. The defense argument in this case is that 12-year-old has been coached and that her mother has provided her information and put her up to the allegations. That 12-year-old in a recorded interview indicates that my father had me participate in several things. I saw that he went inside the car. These are the stalking allegations. I saw that the paperwork that had been taken from Rosalio Gutierrez's car in my father's house. I saw that he brought me along in the middle of the night, leaving the children, the 4-year-old twins behind, to peek into my mother's living room when Rosalio Gutierrez was over at her house. I'm being asked to spy on my father, all these things. He has concocted a false story that we're going to tell to frame my mother into a child neglect type of charge. And as part of what she says, Judge, and as part of what she says, and ultimately she says my father was involved in at his home, at the same place that the search warrant was done. He had a marijuana growing operation. He was manufacturing mushrooms. Here's how the marijuana operation was growing.
How would a 12-year? Well, she was 10 at the time.
Plants. She actually knows the number of plants.
Yeah, see, that's suspicious if an 8 or 9-year-old kid
as I told you yesterday,
knows how many plants her father has and how he cultivates it.
Manufacturer
that smells of serious coaching by
as
mom.
A 12-year-old, and she says he just harvested. He just essentially sold the vast majority of what he had. And when the search warrant is done, all of those things are true. We have all the seeds. we find 2 pounds of marijuana. There is the potting soil with the remains that are in the bags out in the back.
There's potting soil with remains. They also own a fucking tree farm.
Put up to this by her mother, then why is she able to be accurate about things we can independently confirm about that residence? This is very powerful evidence that this 12-year-old is a truth teller about things that certainly implicate her father in many, many ways in a homicide. So, and she also knows, Judge, the exact date that he will be going to South Dakota for sentencing on his multi-pound drug case. So she knows what it is, she knows what his offense is, and she knows the exact date, and that he will be going to South Dakota. And that date, by the way, is just about, it's the 27th, so it's a week and a half away from the homicide date. So this is not a 12-year-old who's being sheltered from her father's information or activities.
Yeah, mom's feeding it to her, probably.
Being entwined in them in a way that, again, if those kinds of materials are not permissible, then she's being coached, does not have that whole body of evidence available that shows that she got a number of things right. So how would the coaching, doesn't that undermine this idea that she's not being truthful in these other ways?
What?
Well, I don't want to jump over onto that.
Okay, well, I only tell you that because for me, it's a two-part, it's a stool that has both legs. It's Marcon Washington's
both legs. The stool has 3 legs, you fuckwit.
Which of course will be under vigorous challenge. And it's a 12-year-old daughter's credibility, who will of course be under vigorous challenge because she says some things that are highly damaging to her father, the defendant in this case. So the discussions we're having are necessary evidence to bolster both of those 2 persons' credibility, and I believe they are admissible based on the things I've indicated. Thank you.
Thank you. Defense?
Yes.
Jesus, that only took him 25 minutes to say.
The fact that Attorney Gravely is arguing really 2 different things here, and I think the court was anticipating this a little bit yesterday afternoon when the court observed that this certainly does appear to be other acts evidence. The initial part of Attorney Gravely's argument was that Sullivan and Whitty are not part of this, and that this really should be treated as panorama evidence. Now, I know that there have been many cases where that type of issue has permitted the introduction of evidence when the state can allege that it's necessary to put something into context. And in those cases where it is admissible, in other words, it's not other acts, but it's merely panorama evidence, it tends to be much less prejudicial and much more relevant in order to give meaning to other procedural or timeline aspects of a case.
Counsel, can you turn your mic on?
It is on.
Okay, speak.
I'm having trouble
People are having trouble
looking at the judge while I'm speaking sideways. So I'll move this way. I like to make eye contact with Your Honor, if that's okay. So again, when we see these types of cases where the prosecution wants to offer evidence that will provide more meaning or context to facts surrounding, it tends to be on a timeline basis. And the case that Attorney Gravely was discussing, it was precisely that. It had to do with events that had occurred leading up to something that the prosecution was successful in arguing that it was necessary to do that so that the jury wouldn't be misled or something's taken out of context or some being given a partial picture. Now, in this situation, we're talking about a wholly separate, categorically different type of evidence. And the reason that it's being offered, if we really are looking at it under this idea that it's to bolster the credibility of a witness, that falls within the other acts analysis. And I'll point to the case of State versus Fink, 95, Wisconsin 2nd, 330, a Court of Appeals case from 1995. That case dealt with the prosecution did file an other acts motion, and it was 1 week before the trial started. And the issue there was, given that that was termed as an 11th hour motion, and the issue there was 1 week before trial. is not enough notice for the defense to be able to anticipate that this will be what we always want to avoid in our other acts scenarios where Sullivan does apply, is a trial within a trial where the proponent of the evidence needs to present facts that the defense is entitled to adequate notice to not only investigate, work it into the theory of defense, work it into voir dire questions potentially, as probably should have in this case, but also so that we're not straying too far from what the central issue is in the case. And that's why 90404 exists, is so that we're not bleeding over into a controversy that is not part of what we're dealing with. I want to point out that all of the cases that we've looked at that deal with the concept of bolstering almost universally involve sexual assault cases, or they're trying to bolster the credibility of a victim in particular. And especially some of the recent cases on that issue, as the court is well aware, both statutorily and case law precedent supports the idea of the greater latitude rule, based on the premise that when there is a sexual assault or a victim of that type of situation, the prosecution is given greater latitude to introduce evidence that would otherwise be barred as character evidence, inadmissible character evidence, for the specific purpose of painting the person as somebody who isn't as innocent as he might appear, to not put that particular aspect of it into isolation. And in those cases where there's been past allegations that have been investigated, or even past similar allegations against another person or the same person, the court should give greater latitude because of the nature of those types of cases and the nature of the victims involved there. So what we're really talking about here is the state hasn't provided notice, and that's why they're arguing, I assume, that this is panorama evidence, because panorama evidence doesn't require notice because it's less, by its nature, less prejudicial, right? Anytime we're dealing with somebody testifying about illegal activity, and I know we've had discussions about the fact that marijuana is not as vilified as perhaps it once was, it is still a discussion about illegal conduct, breaking the law. And there are many cases out there that talk about the fact that it's natural that it would draw opprobrium from the jury in those situations, if it's not specifically tied to something very important to a theory of prosecution. That's where we look at the 90404 and the many exceptions to the character evidence bar. The court's familiar with all of them: motive, opportunity, intent, plan, modus operandi, those types of things that have traditionally been allowed as an exception to that character evidence bar. The important thing to note here is that, just in addition to what Mr. Gravely was arguing, and by the way, I understand that it's his job to anticipate what the defense might argue, but we haven't argued any of the things that he's saying what the defense theory is. I think that's up to us to determine what our theory is and how we argue it, instead of having him speak on the defense team's behalf about what he thinks our theory is. Even if, and I think it's significant that he's explaining how he envisions all of this to be relevant to arguments that he anticipates that we're going to make, that's precisely the reason why an other acts motion should be filed before trial, is so that those issues can be worked out and so the court can perform a detailed Sullivan analysis and also determine the impact that this will have on the way that the proceedings occur. So it's clear that the state either thought that this was panorama evidence and wouldn't need to file that type of motion, but at the same time, they're arguing that for the purpose of witness bolstering, which would theoretically fall under a 90404 analysis, that they should get it in that way as well. But another couple of points to note here.
Why does he sound so much more rational?
This information that the state is alleging that Mr. Washington could not have known about in any other way except for a statement from Mr. Anderson is contained in the criminal complaint for the Ozaukee County case. And in addition to that, I don't know that the state can prove that
maybe because he's
only
not
the
yelling.
media and only this one complaint were the potential sources of information from Mr. Washington. We're getting the speculation about how all that occurred. But a defendant's entitled to have discovery, letters from his attorneys, all types of information in his possession in the jail cell. So to just assume that the only thing that could have possibly been the source of this information and therefore makes this evidence so incredibly relevant is flawed at its base. The second part of that's problematic here is that the state is alleging that because Mr. Washington knows all these details on this aspect of it, he must be believed on the heart of the matter, the root of what we're really getting at here, which is the alleged confession that Mr. Anderson did commit the murder. Again, the state would need then to prove more than just a conversation occurred, because the theory here is that he couldn't have known these other facts but for this conversation. And that's not the end of the inquiry. There's all types of other ways that this information could have been brought to light. So I think that the relevance and significance of the argument to begin with is somewhat limited as far as its overall relevance. But I think the court is correct in your assessment that this does not conform with what the appellate courts want trial courts to do when it comes to a clean trial with a clean record and without muddying the waters with a trial within a trial. So despite the efforts to declare this as panoramic evidence, I don't think it is. I think it is definitely other acts. And I think that the state's failure to actually, and it's interesting because I think I heard the term cornerstone of the case being used here. And if that were so, and if that's truly what the state had anticipated, the massive significance of this to be, then clearly there should have been a motion so that it can be litigated not on day 8 of a homicide trial, but beforehand. I also believe that, and I'll let Attorney Mueller speak on this, there was a specific motion in limine on this.
One attorney.
Yes, sir. Okay.
On a subject. Go ahead.
Okay. There was a motion in limine that was filed on this matter that I believe did directly address this this aspect of it, and the state raised no issue of intending to get into this in any way. I want to talk about some of the cases that were cited here, and I would point out that the Dukes case that the state relies upon does not address this concept of bolstering of credibility directly. The Dorsey case that talks about witness credibility is actually incorporating cite to another case called State versus Menez, which is 331 Wisconsin 2nd, 568, Wisconsin Supreme Court, 2011 or 12, I believe, 11. That case, again, was a sexual assault case where the witness that we're talking about bolstering the credibility of was the victim of the crime. Again, it's a completely different type of analysis. So I think, to make a long story short here, we have a notice issue. We have the fact that I think there are some proof problems. The fact that the state is trying to portray this as, two legs on the stool argument, again, is anticipating quite a bit as it relates to what those credibility
Does
attacks
anybody
will
know
be.
how many
But
legs a stool
that
has?
issue should also have required an other acts analysis. So we're getting a
At least
preview of the
3,
fact that we're
if
going to
not
have
4.
that issue with the defendant's daughter as well. So, I know that the court's very concerned about issues that don't stick to the point, issues that don't relate to what we're really here all about. And the fact that this is a distraction, it leads into other areas. The relevance that's being purported here is absolutely minimal. And it's an improper attempt to, again, in this context, to try and bolster this witness's credibility, who's not a victim of anything. Now, there are the cases that talk about the credibility of, let's say, a co-defendant or something else that is where there's a question with regard to that person's participation in the crime in question. Where again, and then we sometimes fall back on traditional methods of quote unquote bolstering credibility, like prior consistent statements or timing of reporting and those types of things, completely absent in this situation. So this is clearly not something that should be permitted, and we object.
Thank you. Did you wish to respond?
In Korea, the
briefly,
judges
so,
would
the
crucify
cases
you
I
if you
cited,
crossed your
Judge,
legs in court.
draw absolutely no distinction between a victim and a witness, and in fact, a victim, as the court often says in here, is a complaining witness and has to be dealt with by law as a witness. So none of these cases draw a separate distinction saying a victim gets a
Two is a difficult number for a stool to have.
None of the cases I've spoken about specifically rely on any kind of special
Not impossible.
statutory
From an engineering
expert
standpoint.
considerations for sexual assault. And I did mention the South Dakota complaint, and I apologize, I was not complete enough about the details. So that was a September 26, 19 South Dakota arrest, and the amount of marijuana the defendant transported and entered a plea to and was awaiting sentencing that was going to occur on May 27th, I believe 10 days after we alleged the homicide, was 26 pounds of marijuana. Thank you.
Thank you. Well, there are a number of observations. Well, commenting first of all on the source of the information that this witness might have, I do think you're skipping some steps in there when you say, well, he couldn't have found out any other way. Well, there's no evidence of that. It's certainly possible, and there are cases that I've heard that there have been very, very peculiar details about a particular homicide, for example, that the police don't give out to the press or to the general public, that they use later in screening out people who are making false confessions and the like, that they feel can be used to verify the truthfulness of what is being told to them. But even those, I've often wondered, how can you be so sure? You can walk around this building and you can pick up all kinds of things you have no business knowing from well-intended people, and you're the district attorney. I mean, anybody should be able to walk up to you and tell you anything.
And they certainly have.
Oh, Emperor Palpatine found that funny.
To people just coming to you, I think that there are people who tell me things that are none of my business. And but anyway, to me, when I hear the term panorama, I'm familiar with it. I've admitted plenty of that evidence in other cases over the years. I'm thinking of panorama of the case that's before the jury. I'm not saying panoramic evidence cannot include something that is more of a satellite from the incident that brings the charges, but I do think of it as generally filling out the panorama of what's being tried. I often state, and probably did in this case in my voir dire, that the objective that we seek through the trial process is to put the jury back at the scene of the incident and have them make their determinations based upon the fullest possible knowledge. And sometimes that involves letting in panoramic evidence. But on the other hand, when the term panorama becomes an excuse to further push out the borders of what exceptions there are to the general rule blocking evidence, character evidence, there's been a steady growth. there has been a steady growth, and it's been commented on by the appellate courts, usually in affirming it. But you know, it is a problem that we need to be watchful about. I do think this is other crimes, wrongs, and acts evidence. And in this instance, one of the reasons that I make this statement is that the incident that you want this man to talk about right now is completely, totally, and absolutely irrelevant to the story of what happened with respect to Mr. Gutierrez on the day of his disappearance. It is relevant only insofar as it bears on whether well, the definition of relevance is something that makes more or less probable what the evidence would be without it. I'm not quoting it well,
including the credibility of witnesses.
Yeah, well, you're quite right.
This fits the definition of relevance, but I don't mean to argue with the
well,
court.
no, that's if I make a preliminary determination that
don't annoy the judge. Like force lightning is going to come
over
out of his fingers.
the witness's credibility.
Agreed.
The fact that these gentlemen sitting in the jail would talk about baseball scores or football or women or alcohol or whatever, that's harmless, no problem. People can bond over all kinds of things. They could bond over, he looks honest. People saying things like that. He looks honest to me. He had an honest face. But when the, as I say, said a bit ago, when the price becomes admitting evidence of other activity, which though tolerated and even embraced by tax-seeking politicians, is
the judge's son is boomer aged. He's way past boomer.
To bolster the witness's credibility, and the price it's coming at is to accuse this man of a crime.
So
that he is totally unrelated to that for which he's on trial.
It's going to be like yesterday.
So I understand that the court is denying my motion to admit as to them swapping stories about their drug transactions.
You are using the exact term I looked up yesterday. Okay. Very perceptive.
But I want to be sure I understand the court's ruling fully because I'm going to instruct him. So what about him talking about what the defendant told him about the police raid of his home, where there's already evidence before a jury? They've already seen the pictures of what was in the police raid.
I don't know what he told him.
What?
I don't know what he told him. Maybe he said,
well, I'll make an offer to the court.
50 pounds of heroin in the back room. The police never got, you know?
Here's an offer of proof as to what I believe he'll say because it's been disclosed, right? He says when the police raided his house, he says the defendant reported to him, they got a bunch of money and a little weed. Okay. So again, this is already in evidence. The jury's already heard about that. So I'm asking permission for him to be able to answer that question. And because it has to do with drugs, so I don't want to break the court's rule, but from my perspective, that's a different piece of evidence, right? It's already been heard by the jury.
Assessment. What? I think that's true.
Okay, so now I understand. Thank you.
Well, that wasn't the imprimatur.
I apologize.
Imprimatur.
That was
a
unhealthy
approval of the.
Is he having a stroke?
Translates as "let it be published." In the Catholic Church, it and may still be used as a Episcopal bishop's permission for something on the subject of religion.
What are you talking about, Judge?
Dude,
not contrary to Catholic teaching.
What are you talking about?
Oh my God! Yesterday he went on this rant for like 20 minutes. And at the end, they were like, "What was your ruling?" And he was like, "Oh my God, I totally forgot."
That he is not to bring up anything about their mutual discussions about drug activity. If the court permits, he'll be limited to the question I just asked, which is, what, if anything, did the
defendant tell you about the police searching his home, period.
I'll hear you briefly on that.
The admissibility of that evidence when it did occur before that's related to that search was admitted for a limited purpose, and that had to do with impeachment of another witness. That doesn't mean it gets to be used for bolstering purposes at a later point. But we have the same issue here in terms of
this poor jury.
That is all information that is contained in the criminal complaint for the Ozaukee County case, which is natural that Mr. Anderson would have had. But before we go too far and have the same issue again, I'd inquire of the court if your ruling as it relates to this discussion with Mr. Washington about the drug activity also applies to the discussion or knowledge that the defendant's daughter has about the same issue, because it will come up again, and I don't believe the court has specifically ruled on that.
You're correct. I guess I'm back at the same point. The fact that the defendant may have imparted some historical information in his discussions with Mr. Washington. I don't know that somehow is, especially information that be already known to the police authorities. It doesn't really constitute the defendant.
It was supposed to be over tomorrow.
Entrusting to Mr. Washington the innermost secrets of his heart.
Isn't it a valid argument for the state to say that this is something that is information that is confirmed by the rest of the evidence that the jury has heard? So just as each of the things that Mr. Washington says about other specifics about this case or this investigation, to the extent that they can be verified by evidence the jury has independently heard, doesn't that make them more likely to have been said by the defendant? Of course, you can counter that. You can say, well, you could get that from another source. That's, again, a valid response, but it isn't a disqualifying response. It is argument that is a valid and appropriate argument. Again, Judge, we're now talking about whether he can be questioned about something that is already in evidence in this case.
Yeah, I think that's the bottom line. You're correct. It is not in evidence for the purpose that it now is being sought, but it's not going to suddenly astound the jurors to hear this, and for that very reason, its prejudicial impact is diminished, and that is one of the factors for the court to consider. So on this, I'm going to say, okay,
so I just need to briefly let him know, and then I'm ready.
Have him come over if he isn't here.
He's here. I'll just go briefly.
Okay, you can go talk to him.
Oh my God.
Olivia issue. I'm sorry.
We'll cross that bridge.
Oh, he just named the daughter. No,
they did that. They've already done that. They've named her. She was named several days ago.
With respect to minors.
Which I have an issue with personally, that they gave her first name. That's not okay.
All right, while they're waiting here, to call says the fail to exclude thing is as scientifically close to saying yes as you can get. It's the hypothesis testing, essentially the fail to reject the hypothesis response in stats.
Yeah.
Matthew Self, whatever text message tone, like that one that just went off, keeps going off in the court, messes with me. It's the same tone as mine. Morning, Lorax and Chandler.
Morning, Matthew.
And Jonathan, yo mama is panorama evidence.
Solid.
Your mama's so fat, she's a panorama photograph. American
Your mama's
Dreamer.
so fat the panorama couldn't capture all of her in one shot.
Can I get prayers for my 96-year-old mom, please? Her name is Goldie. Thanks, everyone.
Absolutely.
Wow. Prayers to your mother. Don't know what issues she's facing. 96 years. She's seen a lot, been through a lot, and my father's 87, so I get you.
I'll pray for her.
Prayers to your mom.
That'd probably be helpful. Yeah.
Boomer, wow, audio is god awful. You're going to deafen me. That was like an hour ago, so I hope we've got it worked out by now. Wolfram, my suspicion is that the defendant is being Me Too'd by ex-girlfriend, and DA Moron is trying to Murdoch him. Wish I had time to parse that.
Yeah, I don't know about Me Too. That seems to indicate a sexual assault allegation, which is not present here. But I mean, I get the framing aspect potentially. We'll see.
The DA, right. Yeah, he's always saying right. And Chance, welcome to our newest member of the Clean and Sober crew. Thank you for joining. Deeply appreciated. Brendan Co., this dude would be a 10 if he didn't have that stupid mustache. You're either talking about the witness or me. I think I'm a 10 because I have the stupid mustache.
He's obviously talking about the witness. Your mustache is remarkable.
Unfortunately, the witness wasn't here an hour ago when he was saying that, but whatevs. Jonathan, dog cameo. Yoda's asleep on the sofa. Also, I'd like to recommend Steve Gosney's recent stream on Rumble. He talks about the Murdoch trial and flaws in the justice system. Good stuff. Whew. I'll get your shot here in just a minute, Jonathan, because you earned it with that super chat.
Yes. Thank you.
Serial Shot Dodger. My name is Chandler. Says, why is Chandler so mean to me? What? Are you buying Mean Copium's non-pass out sandwich shower bed excuse for the last stream? No, he was passed out. Challenge on that.
How am I mean to you?
Because you're six. You owe him 6 shots apparently.
I thought I owed 5 shots, but I will take 6 shots.
Whatever.
Whichever number is accurate. I'm very.
5. I just made the number up.
Serial Shot Dodger. Are you kidding? I love you. I have no idea who you are. If you're a man or if you're a woman, I don't know what your deal is, but you are a wonderful contributor to this panel.
The Brandon Collective.
The Brandon Collective. I have. Thank you. I'm so sorry you thought I was being mean. I promise I'm a really nice person.
Right. Nick Campbell says, "Isn't 2 considered a Sibian with nub? Just." If you know, you know. Don't Google it. Dirk Diggler, judge is a blabbering, dried brain boomer. He is so much older than the boomer generation. Like I said, his son is a boomer. A.A. Ron says, when I was a kid, my grandma told me about how they used a 2-legged stool when milking cows. It's not engineeringly, it's not impossible from an engineering standpoint. Just 2 is like the oddest number for stool legs. Anyway, totally not a Russian bot. Says drug charges are still pending, so he's supposed to be innocent of that too. Highly prejudicial. Why is this even a thing? But character assassination. I thought he pled guilty to that, and they're just doing sentencing. I can't remember. I don't know. I haven't been following the drug charges.
I'm not certain. I can look into that.
Yeah, I just honestly don't know. So I'll shut my face. Zizix. Your feeble skills are no match for the power of the dark side.
A word about tomorrow.
And Flux, Jeff, I'm bored. Tell a funny joke or something. Here we are.
As you're aware,
that's bad joke.
Have correctly predicted 45 of the last 3-4 storms, the snowstorms. So they tend to overpredict because they don't want to get burned. And that's, I don't know what's going to do tomorrow. We're looking at the situation, and one of the things that we're thinking about is having a call in or a call out, one way or another.
I'm still confused.
Telephonic contact with you. Around 7, maybe 8 in the morning.
Oh, see, now we're getting the audio is readjusted itself, making extra loud.
And I would tell you that it would be unlikely that court would not be held if there's less than about 3 or 4 inches of snow, unless it's blizzard and the roads are severely impacted. So we would generally press ahead, but we have to be realistic about the possibility that there'll be a problem. So is that a situation that wouldn't work for anyone? That if we, either by your calling in here or you being called from here, we let you know whether you should come in tomorrow or not? Anybody have any thoughts on that? Or a better way? Well, think about it, and we'll talk about it later as we get more updates on the weather.
Oh, please give me the day off tomorrow. I'd love that.
Mr. Washington, when last we were in court, I asked you a question about what, if anything, that the defendant told you about a police search of his house involved in the investigation?
Okay.
What if anything, did he tell you about a search of his home?
Well, he told me that you guys had raided his house or whatever, and that you had found a nice amount of money and a little bit of weed.
And what did he tell you about? What, if anything, did the defendant tell you about where his house was, and did he describe his house to you in some way?
He told me that he lived in Mequon and that he owned his house. He said it wasn't big as everybody else's house, just a small little house, but he owned it.
Okay. Was there a time when you were observing the defendant when it appeared to you he was having a nightmare?
Yes.
And what do you remember about that incident?
I remember I was laying there the night before. I told him about it the next day, but I was laying there and I was reading my book and I heard him shout in his sleep before he woke himself up.
Oh no! Now it's gonna be
What
a
did he shout that you heard?
He said, "Die, die, die, motherfucker."
Oh, bull
You're
fucking
quoting
shit!
As best you remember.
Yes.
All right.
Oh,
so,
bullshit!
did you ever have a
I don't believe that for
discussion
a
with the
fucking
defendant
second.
about this
You don't find him
nightmare
credible?
that
I think
you
he's
heard
so
him have, or
credible.
these words he said.
Yes, I did.
Okay, and so if you know about how long after that happened, did you bring it up to him?
I brought it up to him the next day.
Okay, and what did you say to him about it?
I pretty much told him, I asked him about the situation about that he was locked up about, and I told him that he was talking in his sleep or yelling about some stuff in his sleep, and he was like, "What did I say?" And I pretty much told him what he said, and he's like, "Yeah, you serious?" And I'm like, "Yeah, you said it." So I asked him a question. I'm like, "Did you do it?" Like, what? You know what I'm saying? I think you did it.
Oh, Jesus Christ!
We went from there.
And
Yes,
so
I
what did
killed
the defendant
Hitler in my
respond?
dream.
He said,
Oh my
I think
God.
you did it based on the nightmare. What did he say?
I told him to look me in my eyes and tell me that you didn't do it. And he jumped down from the bed and he looked me in my eyes and he said, "I did it." He said,
"Oh, fuck off."
That's the reason I have the nightmares. I'm unable to sleep at night because I think about it all the time.
Wow.
Was there a discussion at some point where the defendant said to you, "Is it that obvious?"
Yes, he did.
And
A little bit
did
leading
that-
there.
Objection leading.
Not to me.
The very definition of leading.
Exactly.
Rephrase your question.
When, if ever, did the defendant say to you,
Oh, that's a
"Is it
lazy
that
ass
obvious?"
fucking way. Oh, fuck.
Objection. Same exact same question.
Okay, Elaine fucking Bretterhoff.
That's taught in some law schools that's not a leading question. Others, like the one I attended, say it is.
Way to go,
so
Elaine
it's not
Bretterhoff.
firmly settled, but
Fucking
I do think in the final analysis, it tends to suggest an answer, so the objection is sustained.
You dickweed.
In the discussion that you had where he looked you in the eye and said he did it, what else did he say? Meaning the defendant.
Well, after we had talked and I told him, I basically knew he had did it, because I've been around killers. I know killers like pretty much, and he seems like a killer. I pretty much asked him like, how did you do it?
Oh, he seems like a killer.
I'm going to object here.
Yeah.
Convict him on the spot. He's going to jail.
Get
He
him
has
off the
no way of
fucking
knowing
stand.
Who's a killer and who
Get
isn't,
him off
other
the
than where he
fucking
has personal
stand.
knowledge.
Wow.
Such as something he would have observed with his own senses.
Well, it's not like he has anything to gain from this testimony.
and
He's just
then
being a
there's
good, honest
people who might
citizen.
make their statement based upon the hearsay that we talk about all the time, and that's not even been stated here. So he's making a judgment just based upon
bullshit.
No basis at all, really, in fact, that would ever be considered admissible in a court. So please disregard that entire statement. Any question?
Get him off
Thank
the
you.
stand.
So when you asked the defendant, how did he do it? What was said next? What did the defendant tell you?
Well, he spoke indirectly. Starting off, he wasn't pretty much trying to say everything that he did. I felt like he was held back, but he said that, well, if you gotta know a person, you gotta learn a person, You got to be able to know, where they live, how they move when they leave, what they drive. And then he told me, one way of knowing when a person is going to be a certain area is GPS tracking. And he told me
Look at his face.
Amazon
Oh my
sells
God.
GPS tracking that you can put on people's car.
Did he use a phrase to describe the circumstances of his case?
What do you mean?
Did he, at some point were you aware of a nickname that some people had given the defendant?
Yes.
And at some point, what nickname did you hear people address the defendant with occasionally?
A lot of times people would say Houdini or Zach Houdini, or, just telling me about who my cellie was.
And did they, and was this a nickname that you, did you understand why this nickname was given to the defendant?
Yes, I did.
And why was it?
Objection.
What's the relevance?
What on earth is the basis?
Because of what the defendant's reaction is to the nickname. So my offer of proof is when the defendant
Wait,
was...
no, Judge.
Well, no, he's talking.
No, but I think...
He's talking.
Okay.
When the defendant was confronted with this
Not
nickname,
in front of the jury.
He, according
Not
to,
in front of the jury.
Witness.
Not in front of the jury.
Jesus.
That is relevant.
Judge, I think that we had, the fact the court instructed us to not go into all of this arguing about evidence in front of the jury.
Yeah, thank you. Oh my God. I want to know what Law and Cuck is saying about this right now.
Jesus fucking Christ.
Oh man, this is bad. This is really bad.
The last question was started with a Y as a word. Why?
Oh, where's the Law and Cuck chat? Oh well, I want to see what they were saying.
Pardon me?
Damn it.
Why don't you start with a new question?
When the defendant was called Houdini by individuals,
oh, wow.
How did the defendant react?
He never denied it. He just would laugh it off, or just go on about his day.
And did the defendant talk about why people were calling him Houdini and describe, what that was about to you?
Yes, he said they called him Houdini because of his case, basically because he made a body disappear, they say, and everybody called him Houdini because of it.
That's not what Houdini did, you fuck
What can you say about how he was acting when he described that to you? Was he sad, regretful, just neutral? Was he proud? Describe his reaction as he had that discussion with you.
Me, I think he was kind of like proud, but not really showing it. Like he kind of smiled it off. I mean, in jail, like you when you're around people, you got to have like this kind of name for yourself. I don't know. Everybody fighting the same battle in there, so everybody fighting different cases, and he kind of like his case is big, and because of it, everybody know him. So he kind of like wear that jacket a little bit. He doesn't admit it to everybody, but he does wear the jacket, in my opinion.
I mean, my nickname in college was Napoleon.
And,
obviously,
what, if anything,
I was responsible
did the
for the
defendant
French
tell
Revolution.
You about the circumstances on how he committed the crime? So you've already talked about, he said it took a lot of work. You got to follow the person's patterns, trackers from Amazon. You said all that. So what did he tell you ultimately? Were any of the circumstances he told you
I'm
about?
sorry for cursing Allison Holmes' dad, but I'm angry.
Yeah, he ultimately pretty much just told me that.
Well, I don't want to hear testimony. He pretty much just told
Okay.
me.
Well,
I'm not scolding you. I'm just telling you. You can quote exactly what was said,
Correct.
But we don't want your
pretty much
conclusion pretty much told. Okay.
Okay.
And Judge, a witness is not going to be able to exactly quote. We're not computers, so he's going to say, "Here's what I believe I was told." Right?
Well, I understand your point is legitimate.
Okay. So,
however, that's a flashing warning sign when someone states he pretty much said thus and so. Mm-hmm. You may be able to access the information you seek with a different question, but we're 9 days into this trial.
Yeah.
we don't want to ignore flashing warning signs.
Okay.
Just
So
get him off the
what
fucking
did the
stand.
defendant tell you about how he committed the case that he's charged with, and what the circumstances were?
He said that he had seen this person, and he said he stabbed him, and he blacked out. He said he stabbed him, he stabbed him, and I just blacked out. And he said he eventually wrapped the body up in garbage bags and got rid of the trash. He threw the trash out.
Okay.
And I asked him, what did he mean by that? And I said, what, like dumpster or trash? And he said, once it's gone, it's gone.
So rather than blunt force trauma being beat with a baseball bat or some other blunt instrument and rolled up in a carpet,
What, if
he was
anything, did the
stabbed and
defendant
rolled up
say
in
about
plastic bags?
whether after
They're going to eat this fucker
killing this
alive on
person-
cross-examination.
Well, all right. So
I cannot wait for cross.
They're going to eat him alive.
based on what you've said, putting in trash bags, it won't be found. Did you ask him any follow-up questions about things like how he moved the body?
Of course he did.
Yes.
Okay. And what did the defendant tell you about how he moved the body of this person?
Well, I asked him, like, cause I'm like, you did this by yourself, pretty much. Well, you did this by yourself, and he said yes. He said he took him on his own. He didn't have his help with his brothers, because you guys said that his brothers was involved with this. He said he did not have any help. He did it all by himself. And I'm looking at him.
What?
Like, okay, don't look. I don't know if he was telling me the truth or not, because
look at the defendant.
But he said,
look at the
you should have
defendant.
seen me before
He wants.
I came
He
in
wants
here.
to kill
He was
this
like,
guy.
I was real cut. I was healthy. I was
This is
strong.
bullshit.
When I first came in here, everybody was calling me Superman. So I'm like, oh.
And did he say, other than his own strength, did he say any other reason why
Bullshit.
he felt like he'd been able to do it himself?
Other than strength and adrenaline, that's everything he said.
Now, did you ask him, what, if anything, came up about why he did this? Why would he end this person's life?
He said to get back at his kid's mother.
And what did he tell you any more about that?
Yeah, he said that he was angry with a bunch of different things, but he said she kind of bragged about this other guy and that she was happy.
This is horseshit.
He didn't really want his
Notice
kids on
how this jailhouse rat, this rat fuck, this snitch has asked all of the important
Other than the
questions
details
that a
you've described so
prosecutor
far, did
seeking
he
a
provide
conviction
any other
would ask.
details to you about the offense or any other of the circumstances of this case, other than what you've said so far?
He didn't really speak much. He told me what he told me, but he did say no case. I mean, no body, no case. And that was
Oh my
where
God.
he left it at, pretty much.
Now, when you were originally debriefed by the government,
Mhm.
were you asked about whether you knew of any other crimes?
Yes.
Part of that? Okay. And that was back in 2022, correct?
Correct.
And did you bring this particular incident that you have told us you heard from the defendant? Did you bring that up originally when you talked to authorities?
I thought about it, but I did not.
Okay, so can you describe to the jury why
You thought about it.
you had already been confessed to by the defendant? Why, when you were debriefed in 2022, you didn't choose to share this with anybody, any authorities?
Good question.
Initially, I didn't know if me being federal, that would be something that I could use. And then I also didn't want to deal with everything that came with it. Like being,
Sure.
like being put out in the open, like over the news, all over the media, that comes with risk factors. That's a lot of stuff that I wasn't really know if I was ready to deal with.
So, best you remember, had you told anyone about what the defendant had told you up until just a few months ago?
No.
Okay. So, do you have an attorney in your case?
Yes, sir.
And who's the first person that you decided finally to share this information with? Who'd you tell first? Hey, I know some facts about what Zachariah Anderson did.
My lawyer.
Okay. And did you,
Of course
and what were your instructions to that person? So when you told them, did you ask that person, hey, tell somebody this, or what happened?
I talked to him about, because like I said before, he asked me, what all did I know at this time? Like, are you sure you don't know anything else? And I pondered about bringing that up again, and I brought it up to him. I was like, well, I do know something. And he said he was going to look into it, and he got back to me, and he told me you really should speak up about it.
And after hearing that from your lawyer, did you, what decision did you make?
I spoke up about it.
I'm disappointed he didn't say that he was afraid that Houdini would disappear him too.
Yeah.
It's kind of what I was expecting. This is bullshit. Who the hell is buying this? I mean, oh my God.
I hope the jury's not. I mean, I hope to God they're not.
If they are, I mean, okay, this is also the jury that acquitted Kyle. This is not the same jury, but this is Kenosha. And people in Kenosha acquitted Kyle Rittenhouse because they knew that those charges were bogus. So I
during the time that you roomed with the defendant, describe his sleeping habits if you can.
He barely sleeps. That was one of the reasons we was able to get along. I mean, we both had different schedules. Well, he didn't sleep really at all.
Relevance.
Goes to the discussion of the nightmares that he had, and is a part of the discussion where go ahead.
He didn't even get his explanation.
Yeah, well, he barely sleeps, like I say. Before I got in the room with Zach, he had told me from the dribble, like, dude, if you snore or anything, I can't be sealed up with you. I'm either go to the hole or you gonna go to the hole, because I barely sleep at night, and when I do sleep, I like to stay asleep. And I'm like, okay, so being in the cell with him, it worked out fine. That's why we was pretty much good cellies, because I stay up all night and he stays up all night, so he goes to sleep first. By the time he falls asleep or drift off for a little bit, I fall to sleep too, and it's pretty much breakfast after that.
He falls asleep.
Yeah, and then it's pretty much breakfast after that.
He's intelligent enough to ask whether he could use this in a federal case.
Oh, all right, here we go.
Oh my God, this is okay. I wish I had.
Who's doing it?
I
hope she just.
Tequila. Oh my. Okay.
Yeah, I owe Jonathan a shot, and I'm ready for fucking alcohol at this point.
I'm gonna get my shot glass. I'm getting my shot glass. I'll be right back.
As you wish.
Cheers, Jonathan. Thank you so much for that earlier $100 super chat. This is utter horseshit. Utter horseshit.
Show this counsel to us before.
Wow. Let's go. Jonathan, what, if anything, detected? God, my blood pressure is pounding right now. I mean, seriously. Fuck. My heart's not beating that fast. It just feels like it is. Nick Campbell, the DA went to Elaine Brederhoff School of What If Anything line of questioning, and the judge made him eat his lunch. Unhung hero, let me ask a question. How is this admissible? It's bullshit. And Jailhouse confessions, these Jailhouse rat fucks, they're all absolute horseshit. They're all lying to get their sentences reduced.
Can you hear me okay?
Yes.
Per usual, I was just joking. Chandler should get in chat. I don't know what her at is, but I'll collect on those shots today.
All right, I got one for you, Brandon.
Next up, Ouija board confessions to the guards. Wine moms are like, I get the same killer vibe, says Legendary Racing. A conservative Husker, Jeff is so emotionally invested in the defense's success. Fail. Just in case there's any question, no, I'm yelling to get him off the stand because it's improper, not because I want the defense to do it and succeed.
This is one of the funniest testimonies I've ever seen. Did you take your shot already?
Oh, no, I'm sipping gently.
Okay.
No shots. I'm sipping.
Okay. I'll sip along.
Sipping a Glenfiddich 18-year scotch. Yum, yum, yum. Yeah, I'm not saying that because I want to get off the stand, get him off the stand because I want the defense to win. I'm saying because he shouldn't be there. They told him the brothers were involved. Yeah, I caught that. I'm glad you caught that. They said the brothers. He didn't say the brothers were involved because you guys told me he wasn't involved or something like that. He got tripped up somehow on that brothers being involved. Oh Lord. C. Suitor. No one can actually believe this guy, correct? I fucking hope not. I seriously fucking hope not.
You'd have to be very stupid. But
Vermillionaire. You know. This is the best witness ever, lol. It's not fucking funny anymore. This guy is so bad it's no longer funny. Convict him on dreams, nicknames, and a lot of coaching. Can't wait for Cross. We're about to get it, I hope. No way he's telling this guy anything. Yeah, this is effing bonkers, says J. Cal. Or Jakal, however you want to pronounce that. I feel sick watching it. Me too. I'm livid. Moral of the story: the system will blow your back out. Yep.
I just wanted to let Brandon know that this is a much larger than average size shot glass, so it looks like a half pour.
That looks like a half triple. Pour.
Yeah, it's big, so I'm just letting you know. I'm taking full shots.
That's at least a double, possibly a triple.
It's a big shot glass. Yeah, thanks to Emma. Thank you, Emma.
Sounds good. Sounds good. Okay.
Kelly R. stopping in from Law and Crime Chat. The orange jumpsuit guy is so credible.
Ask me to rephrase it. I'm glad to do that. Okay.
Die, motherfucker,
I'm going to ask you some questions about your current federal case and some of the interviews you gave. Okay.
Okay.
Okay. If there's ever a time that you want to confer with either of the district attorneys before you answer, let me know.
Okay.
Okay. And maybe if you could like scooch up or pull the microphone up a little bit closer and talk right into it, because I know you're a little soft spoken.
And pull your head out of your ass. Chaz, send me a Twitter message on Twitter or an email.
Right.
thelegalvices@gmail.com.
I want to start with on October 5th, 2021, you were indicted in the Eastern District of Wisconsin, right?
Yes.
And I'm going to show you what's been marked as Defendant's Exhibit 246. Do you recognize that?
I do.
What is that?
That's my indictment.
That's the original indictment?
Yes, sir.
On October 5th, 2021?
I believe so.
Okay, and that indicts you and 13 other people in a drug conspiracy. Is that right?
Wow.
Correct.
And the drug conspiracy is a conspiracy to distribute both, and it alleges in the complaint, in the indictment, 280 grams or more of a mixture containing crack cocaine and 5 kilograms or more of a mixture containing cocaine, right?
Yes.
But of course, as you talked about on direct, the amounts were far greater than that, right?
That's what they say, yes.
So as part of this, you're going to enter into a plea agreement, which we'll talk about later, but you're going to enter into a plea agreement with the federal government, right?
Yes.
And as part of that, when they give you the plea agreement, they give you an attachment with all of the activities that you and all the co-defendants did as part of this conspiracy, right?
What they believe we did, yes.
And well, it's what you're going to admit that you did, right?
Oh, yes.
So, because you can't enter into this plea agreement unless you admit your guilt, correct?
Correct.
All right. So, in this case, you and Brian Phillips and Gerardo Laro are accused, well, at least in the attachment to the plea agreement, of pooling money to buy kilos of cocaine, right?
Yes.
And just the three of you alone got more than 9 kilos, right?
Well, that's what they say, yes.
That's what they said.
They say.
That's what you know, right?
I didn't say I know that.
Well, are you going to admit to it or not?
You said to the district attorney on direct examination that the entire conspiracy did more than 30 kilograms of cocaine, right?
No, that was for me. That's what the drug amount they put on me.
That's just you. That's what they call relevant conduct, right?
Correct.
And that's directly attributable to you?
Correct.
Okay. And so you did that with Mr. Phillips, Mr. Laro, and others, right?
Yeah.
And you did that in the context of being a a gangster disciple, a gang, a street gang, right?
That's what they say, but we're not gang members, no. But yes, you can say.
Well,
whatever the paperwork says, yeah.
The paperwork says that, so you're going to have to.
I'm going to interrupt.
Okay. Yeah.
Who is your attorney?
Matt Ritchie.
He's not here.
No, Mr. Ritchie is aware that he's testifying and is.
He's not admitting
supportive of
anything.
his testifying in this case.
Has the agreement with the United States been signed?
No.
Not a signed agreement, but not only has the U.S. attorney approved this this testimony, but so has his lawyer.
He's not admitting
It
to
hasn't
it.
gone to judgment yet.
Correct. No.
So the attorney's aware he's testifying.
Yeah, I spoke to him yesterday.
Not
morning.
just about what he allegedly heard from the accused, but also as to his own alleged criminal misconduct.
Well, I mean, he's aware if you testify in a case like this that there will be questions asked of you, to you about. I mean, this is a attorney who has entered a federal agreement with him and was the one who coordinated his testifying with us.
This is so weird.
Some of the questions you're being asked relate to your own personal conduct that could expose you to criminal prosecution, and statements that you make can be used as evidence against you. You understand that?
Yes, sir.
You've got a pending case right now. It's not gone to judgment. It's not been resolved. You haven't entered a plea. You have an agreement to enter a plea, but until the judge accepts it, it's not going to, it's still a pending case. So you have the right to talk with your lawyer about any question that seeks information about your own personal conduct. Do you understand that?
Yes, sir.
All you have to do is tell me
He
you want
doesn't.
to talk to your lawyer, and you will be permitted to do so. You understand?
Yes, sir.
Any question about this?
Yes, sir.
All right.
We might turn up the court volume a little bit. Seems like it's a little quiet.
So I'm going to object to the question of gang membership. I don't know why that would be relevant to this inquiry.
It will become relevant.
Go ahead.
Thank you. So the three of you were involved in conspiracy. Well, there was others too, like 13 total, right?
Yes.
And you shared an apartment, right?
That's what they said, but no.
You didn't share an apartment?
No.
Okay. You stored your money and your drugs in an apartment, right?
It was an apartment that we all frequented, but
right.
And we used from time to time because we dealt with the same people.
Yeah, I wasn't saying you lived there. You shared it to use it for drugs and money, right?
Yes.
And you also shared the same supplier, right?
Yes.
And you.
This guy's not admitting to
engaged in
anything.
Fronting drugs to other individuals to sell, right?
Yes.
And you also pooled your individual money to buy drugs, right?
I didn't do that, but people on the case did, yes.
But other folks in the case did?
Yes.
And you were kind of the head of the whole operation, right?
No.
No? Okay. So you would also service each other's customers, right?
Yes.
So you would share drug supplies and drug packaging, and is that right?
Yes.
And you would also share rental cars in order to service drug sales, right?
Well, that's what they said, but I didn't do that, no.
You didn't do that?
No.
Okay. So, and most importantly, you were designed, the whole thing was designed for you to protect each other from detection by law enforcement, right?
That's what they said. That was their opinion.
Well, and so let me just get this straight then. When you go to enter your plea in federal court in front of Judge Edelman,
mm-hmm.
you're going to deny that.
It's a few things that I am going to fight before I sign my plea, yes.
Okay.
Well, that's not
Did you
really
talk about that with
a
Mr.
plea
Ritchie, your lawyer?
agreement then.
Yes, I did.
Okay. So that was the scope of the conspiracy, but they also had, as part of this indictment, had, by the way, I would move to admit defendants D46.
Any objection?
No.
So-
Identified that by
It's a,
literal description?
yep, it's an indictment.
246.
It's
Yep.
the indictment?
The indictment.
I hope they rip
There's
his
another
plea
that's
agreement.
superseding, but that's a different name. So that was the scope of the conspiracy, but also you had, they had some controlled buys on everyone else that was in the conspiracy, including you, right?
Yes.
And between March 14th, 2021 and October 21st of 2021, they did multiple controlled buys with you, right?
Yes.
Totaling 38.7 grams of crack, right?
Yes.
And they did
Yes,
buys from
lying piece of shit.
from 11 other folks, right?
Yes.
You think?
They also allege that you threatened one of the informants, right?
Yeah, they said I did, but that didn't happen.
And that occurred on July 10th,
plea agreement. He's not
2021,
admitting
right?
anything.
I believe so.
Yeah, and so that was where you and Mario Johnson were out looking for this individual because you thought he was an informant for the police, right?
That was a lie as well. We already knew he was an informant for the police.
Okay, but you were driving around in a black truck with guns looking for him, right?
That also was a lie.
That's a lie. You're going to deny that when you go in front of Judge Edelman.
Yes.
Got it. Okay. Just want to make sure we're on the same page. All right. So this indictment in Defendant's Exhibit 246, which was filed on October 5th, 2021, you weren't arrested right away, right?
No, I was arrested, but not here.
You were arrested on October 20th, so 15 days later, right?
Everybody was, yes.
Right. And that was the day they did a raid on your girlfriend's house on Chicory Avenue in Racine, right?
My kid's mother house, Chicory Road. Yes.
Chicory. Sorry, excuse me. So, and there they arrested you and they found a backpack with $24,000 in cash, right?
They did not arrest me there, no.
They didn't arrest you there,
No.
but they found the cash, right?
They found her with money, yes.
Okay. And they also found a Taurus G3C 9mm in a small dresser in the closet of the master bedroom, right?
I believe so.
Okay. And that was yours, right?
No.
No?
No.
Okay. So now, shortly thereafter, the original indictment was filed on October 5th. And on November 2nd, they filed what's called a superseding indictment. Is that right?
Yes.
I'm going to show you what's been marked as Defendant's 247. What's that?
Yes, an indictment.
I'm sorry?
That is the rest of the indictment.
That's the superseding indictment, the second indictment, right?
Yes.
And, excuse me for 1 second. So, just about a week after they raid your girlfriend's house, you said they didn't arrest you right then?
No.
When did they arrest you then?
They arrested me on the highway.
Because you weren't at the house when they raided it?
I didn't live there, though. It wasn't my home. But when they did the indictments and they came and rounded everybody up, I was on the highway. Everybody else was at their homes.
Okay. So in the original indictment, they charged you with conspiracy. First, I would move to admit Defendant's 247, the superseding indictment.
Well, subject to the questions. So far, there hasn't been any questions.
We identified it.
He identified it.
Okay.
Received.
So the original indictment alleged a a conspiracy running from January of 2020 until October 5th, 2021, right?
I believe so.
And also one additional substantive count of you delivering crack cocaine on April 21st, 2021, right?
Yes.
We talking about the original indictment 2.6?
Yes, I'm going to compare them to, right?
Okay, so Judge, I'm going to object to the nature of the question of comparing an indictment that no longer exists to the new one. I have no objection to getting into the new one, but why does the comparison matter in terms of this witness's
Well, I'm just going to
veracity?
assume, and correct me if I'm wrong, that that was part of the
I took two. So,
concession.
but I will
No, I
do
assume
that.
this will be, this is not an.
I'll make it relevant, Judge.
All right.
In the next question.
All right.
Well, I'm not comfortable with, just to apologize, Judge, I'm not comfortable with assurances I'll make it relevant. That's.
Well, so
I'm ready to pounce.
I'm well aware. I'm on notice. Thank you, Judge.
He's ready to pounce.
So the superseding indictment then adds a count for you, a felon in possession of a weapon, right?
Correct.
And they could have, if they wanted to. You're familiar with what a 924C is, right?
Yes.
So a 924C is a federal statute that charges possession or use of a firearm in relation to a drug trafficking crime, correct?
Correct.
And you've talked about that with your lawyer, right?
Yes.
And that contains a 5-year mandatory minimum consecutive to any other case, right?
Yes.
And if it's used, or if it's drawn, it's 7 years, and if it's used, it's 10 years mandatory, right?
I believe so.
Okay. So, but they didn't charge you with the 924C. They just charged you with the felon in possession, correct?
Hold on. I'm going to object to the relevancy of this. Again, what we have right now is that this is an indictment. I believe that I have it written down as dated November 2nd, 2021. So it predates anything that has gone on in our case, predates any contact with our case. So why would whatever the maximum charges versus what the federal government charged him, why would that be relevant to his veracity in this case, to his being?
Let's. You're welcome to go upstairs if you want, but I'm hoping this will be brief, and you can remain down here if you prefer. Don't talk about the case, please.
Oh my. Holy
There's always
crap.
something with this trial. What's happening now?
This guy is insane. Nicholas Starr of Union Rep Labor Law. Subscribe to his channel, by the way. So, Miss, the missing person cheated on you with multiple women. You're just starting the stream, aren't you? Flux, I'm doing a 1K stream tonight. Was going to talk about that. But after today, guys, tonight, 7 p.m. Eastern time, we're going to learn all about jury nullification. Go check out Flux's channel. She just got her 1,000 subscribers. She can start grifting. Flux's channel is House of Flux, all one word, 2 X's, HOUSEOFFLUXX. Great channel. Go check her out. Chris Mullen, I don't care if he's guilty or not now. I want the jury to find him innocent because the prosecution is so slimy, and F them. Yeah. Only thing worse is Aaron than a Taurus handgun is a hit point firearm. There's not much that's worse than a Taurus. You are correct. Serial Shot Dodger, my name is Chandler. Says Chandler, you need to get my Twitter name from Jeffrey. You also need to take 5 more shots unless you can talk me into a plea deal.
Oh, I'm taking them, but I took 1 more, so I owe you 4, and I will do that. I will ask Jeff. I'm sure that he will oblige.
Oh, dear.
Am I wrong?
Yes, you're wrong about everything, whatever you were just asked.
Good question. What a shit show.
I am super stunned by all of this. Anything you want to add to that? I'm just literally speechless.
Well, the chat is saying I'm super loud, so I'm going to adjust my volume first. How did that happen? All right, hopefully I sound a little better to everybody. Let me know.
This is a bad TV script, is what this is.
Okay, I'm just going to say this is absolutely fucking ridiculous. I've never seen a witness like this in any trial. The idea that dreams and nicknames come into evidence is, I mean, I really can't remember anything absurd as this since like the Twinkie defense, honestly. There's a lot of fuckery going on here, and I just love thinking that the DA is sitting there going, this guy's a great witness. He's totally going to convince the jury that this guy killed that other guy. Like, are you kidding me? Oh my God.
I'm scared. I'm scared that people are buying this. I'm scared. I don't trust juries anymore. I just honestly don't. I want to see if we can get. There we go. Let's see what Lon Cuck is saying.
The basis of my objection is I don't think
Love
it's
this
relevant,
courtroom.
What charging decisions the federal government has made, whether they could have charged something higher and have charged something lower.
What is going on?
That's the current inquiry. So if it predates this case or doesn't have to do with any cooperation agreement, so this is at the time of indictment, then I don't believe it's relevant. So the machinations of the federal government before they are in a plea sort of posture, perspective are
slimy defense lawyers.
Certainly anything that happens after we have an agreement or they have an agreement is.
So the relevance, Judge, is that he knows what a 924C is. It's a very serious offense used quite often by the federal government as a lever to get people to cooperate. And he's not currently charged with it, but that is a very, very common occurrence in federal prosecutions where if you end up going to trial, then they add it on. And they also add on something called an A51, which doubles some of the mandatories. So a lot of that is left off the books, but everybody knows it's there.
Well, but the critical reason I'm admitting this evidence is that it bears upon any concessions which may have been extended to this witness to induce him to testify. And am I understanding you're claiming that this superseding indictment was submitted, was returned before this crime allegedly was committed?
The superseding indictment is before he ever enters any cooperation agreement. He is in no way in a cooperating posture. What we're talking about right now, the superseding indictment, is the charging decision made by the federal government when they are placing him in custody and beginning the process. It has nothing to do with cooperation from anybody, from us or anyone else.
Well, I don't know that, and Mr. Birdsall has stated that it's not needed. Well, I think he said sometimes they add these aggravating charges.
I'm aggravated.
When you go to trial. So there's some leverage there to the federal authorities. And the question then becomes, and I don't want to get bogged down on this, whether the federal authorities are aware that the witness has information that the district attorney would desire.
At the time of this indictment, they do not. At the time
The superseding indictment?
Correct. Both of these indictments that have been talked about so far predate any information with the DA's office. Okay. Again, this is November 2nd of 2021.
Well, the filings predated.
That's when the filing. Well, and that's when the charging decision is officially made. There has been no discussion of our case in any way, shape, or form until January of 2023.
I don't think that's the objection was. I think the objection was that 924C wasn't alleged in there. It's just lurking out there. It's lurking as a potential hammer that hasn't been lowered yet.
Mm-hmm.
But if they go to trial, then oftentimes those are added.
But that could be just I'm sure this wouldn't be stated, but it could be used as leverage just to prevent the defendant from exercising his trial right.
That's correct. That's exactly what it's used for.
It's what we do nowadays in the
I know.
feels to me like that's an inappropriate question to say you
It might
haven't
be.
been charged with something where if you exercise your right to a trial, you will get this extra piece.
Are you talking about what theory is or what reality is?
Reality that how is that? How does that go to his credibility? He's allowed to go to trial. So something held over his head about whether he goes to trial is not commenting on his credibility as a witness.
We're not commenting on his credibility as a witness in that regard. What this all is shaping up for is why he's here today. And he's here today because he's cooperating. He's cooperating because of all of these penalties and potential penalties. So the ones
but the possibility of being charged with these aggravating matters may be as much related to the desirability from his point to making a deal, but not this specific deal of assisting the district attorney in Kenosha.
That's true.
It might be a little speculative.
I can just have a couple of questions about it and move on. It's not a centerpiece of my cross-examination.
And it feels like he's either being asked to speculate on what happens in the federal system, and this is, as far as I know, this is his only venture through the federal system, so he certainly could not testify as an expert about, I mean, it's speculative for him to talk about the federal system.
I'll ask him. We already know he has a lawyer. We already talked about it with his lawyer. I'll ask him. I'll ask him what he knows about it.
He will be asked whether it's common. This was the question that was asked that I objected to. Is it common in the federal system for people to add this particular indictment? So you would face those consequences.
That was not
How
my
will
question.
he know what's common?
That was not my question.
Well, why don't we do this? Why don't you rephrase your question?
I will do that.
I'm open to some area of inquiry on this line, but there are many considerations that one might make when deciding whether to hasten to deal with the prosecutor. And I don't want to give the jury the impression that it relates to this case unless there's some evidence that it does relate to this case.
I understand. Yeah, I'll tighten it up. No problem.
Ask the jury to come back in, please. Do you need a break? Well, just let me know if you do.
Wow. Ugh. I got nothing. I'm just stunned here. Let's read Serial Dodger again here. I'm an R slur. Can't figure the DM out. If you can dodge a shot, you can dodge a wrench. Vices, make me a mod so I can see my comments in chat easier.
Here's dodging shots. Not I.
No, not her. And it's hard to add you as a mod because you change your damn name every 5 minutes. It's hard. Oh, crap. Wow. This is the courtroom clock. It says it's 11:05. This guy just needs to be served his head on a platter.
Mr. Washington, the superseding indictment, you said you knew what a 924C was?
Correct.
And they didn't charge you with that?
No.
If you went to trial, was it your belief that they could add that charge?
No. I wasn't worried about the gun because, like I said, I wasn't around the gun. I was on the highway.
Okay. So, but you have now a new legal hurdle, this felon in possession charge, right? With the superseding indictment, right?
It came with just a 2-point enhancement or something. They didn't charge me with the gun or something like that, but it's just an enhancement that they gave me for my charges.
Well, are you thinking about the sentencing guidelines or the actual charge?
The guidelines.
Okay. So we'll talk about the guidelines in a minute. Well, maybe we'll talk about them now. what you think is that the gun is only an enhancement under the guidelines, which are not mandatory, right?
I believe so.
Okay. But you understand that the superseded indictment actually is a substantive criminal charge against you for being a felon in possession of a firearm, right?
Correct.
Now the guidelines, I assume you did a guideline calculation with your lawyer, right?
What's that?
Things, yes.
Okay. Maybe just, yeah, just maybe.
Got to speak into the microphone so everybody can hear, please.
Like I'm right next to you and I can barely hear you.
Yes.
Okay. So the sentencing guidelines, you understand, are a situation where they have a whole set of criteria to determine what a recommendation to a federal judge will be about your sentence, right?
Correct.
And those are just recommendations, but they're oftentimes followed. Is that your understanding?
No.
No, they're just recommendations.
Correct.
And in your case, there's those are based on having a look at your criminal history, right?
I believe so.
And then, so there's two aspects. One is the criminal history, and the other is the actual offense, right?
Yes.
And so they take the actual offense and they come up with what they call offense levels, right?
Yes.
And there's a base offense level for the offense itself, right?
Yes.
And in your case, the base offense level is 32, right?
I believe so, yes.
And so what you were talking about is you think it's an enhancement. What you're talking about there is an enhancement for having a firearm in the conduct of this offense, right? And so it bumps it up 2 levels.
Correct.
Okay.
That's what they did.
And so you not only have that, but you also have the actual charge itself, right?
I don't know if I got the charge on her. I thought the charge might have got taken off or something, but either way, I was fighting that charge.
As part of your agreement, yes, right? As part of your agreement, that charge is going to be dropped.
The plea that they offered me, the 10 years, yes.
Okay. So, yeah, that's, so.
I'm sorry, I missed that. What was his answer?
His
answer to whether it was going to be dropped, that with the offer of 10 years, yes?
I think that's what he said.
Okay.
That's correct.
Thanks.
So, and what you're referring to is the mandatory minimum of 10 years for the crime of conspiracy to deliver controlled substances, right?
Right.
And specifically in the indictment, when they allege specific amounts, and I'm looking at page 2 of Defendant's Exhibit 247, the superseding indictment, when they allege
they can't turn it.
280
They love
grams or
him.
more
They have
of
to love
crack or 5 kilograms or more
He's
of
their big
cocaine,
witness.
You understand that those levels are specific statutory levels that kick in the mandatory minimums, right?
Correct.
I'll be back.
And so those mandatory minimums are designed, well, the effect is that if you are convicted of that specific offense and you go in front of the judge, and even if the judge wants to give you probation or a minimal sentence, he has no choice but to give you the 10 years, right?
Correct.
And this is the first time that you've been in the federal criminal justice system, right?
Correct.
And you would agree that it's kind of a scary place for you to be, right?
I guess so.
Well, you're kind of worried about the 10 years. Can we agree on that?
Yes.
And you want to not get the 10 years if you can help it, right?
Yes, I don't feel I deserve 10 years, so yes.
Okay. And so I'm sure you talked about this with your lawyer, but the only way, the exclusive way to not do the 10 years is to cooperate with the government, right?
Correct.
And that's what they call quote, substantial assistance, right?
Correct.
And the way it works, you tell me if this tracks with your understanding and your discussions with your lawyer, but you agree to provide substantial assistance to the government, and then they decide whether or not it's substantial, right?
I believe so.
And then they decide if it is substantial in their view, that they will file a motion with the court to go below the mandatory minimums, right?
Well, I believe so.
And unless they file that motion, you're going to get the 10 years, right?
I believe so.
So any cooperation you provide, whether it's a debrief in front of agents or testimony in live court, it better be happy, it better make the government happy, or they're not going to file that motion, right?
I believe so.
Okay. I mean, this is a discussion you had with your lawyer, isn't it?
Well, you've inquired about this several times, and I'm a little uncomfortable about your asking him questions about his communications with this attorney.
Oh, okay. Well, I will not do that anymore. I'll just ask him what he understands.
No, you won't.
Wow. Now what are they arguing about?
Move to something else.
Moving on.
We're talking.
Well, he went into attorney-client privilege.
Privileges in our law that, as a general statement, with some exceptions, communications that you have with your physician or healthcare treatment discussions generally can't be admitted in court without your permission. A conversation you have with a religious figure, like going to confession or some equivalent, depending on your religious beliefs, generally can't be admitted in court. Spousal communications, and that's expanded to other relationships now too. But there are some areas that can't be inquired into in court, including conversations that you have with an attorney who's representing you in a case.
You can ask him about it, what he talked about his attorney with. It's up to the district attorney whether or not he objects.
And a waiver by the
judge is just being overly cautious
and
here.
Because the attorney is not here to consult with this man, I'm just
going
to ask that Mr. Birdsall go to another area.
Not again.
Thank you, Judge. This superseding indictment is filed on November 2nd, 2021, right?
Right.
You are in custody. Well, you're in custody by that point. And you're somewhere in some federal holding place, right?
Correct.
Did you immediately come to Kenosha?
After a couple of months, once they transferred me here from down south, yes.
From down south?
That's because I told you I was pulled over on the interstate, so I was in Memphis.
Okay.
Oh, I see. I didn't realize you were out of state. Okay. So it took a little time for you to get extradited back here?
Correct.
Okay. So when you do come back to Wisconsin, though, you come right to Kenosha, or do you go to one of the other federal holding places?
They brought me here.
To Kenosha?
Correct.
In KCDC?
I went to the county jail first.
Okay. And then you get transferred out to KCDC?
Correct.
All right. And there's a bunch of other federal inmates there too, right?
Correct.
So you're housed, if I understood your direct testimony, for about 5 weeks from December 22nd, 2021 to January 31st, 2022, right?
I believe so.
Okay. And that's the period of time when all of the testimony that you stated on direct about what Mr. Anderson said to you and all that, that's when all that supposedly took place, right? Okay. So,
yes.
So you get moved out on January 31st to some other place inside KCDC?
Yes.
And I believe you said in your statement to officers that it was some sort of classification change?
Yes.
What was the classification change?
Objection irrelevant.
Overruled.
I'm a federal inmate, so our level starts at 4. So we initially not supposed to be back there with those guys, but they didn't have the space. And Zach had told me that I was initially going to get moved. Eventually, he was telling me to get my level lowered if I wanted to stay back there because I was a good cellie. But I was new there. I wasn't finna get tickets or go to the hole or mess up myself. So I didn't do nothing about it, and they moved me.
Okay, so you're a classification 4. I don't really know how this works. So how high does that go?
I'm not sure. I done heard people have 5s and stuff like that, but a 4, from my understanding, is supposed to be minimum status, something like that.
Okay, so 4 is minimum, but like higher is
Minimum
worse?
as well.
You don't know.
Lower 2s and 1s or 2s and 3s are what they call bad, I guess. I don't know.
Okay,
high
so it
bond.
gets worse as you go down.
Correct.
Okay. So, but in any event, you move on January 31st to some other location within the KCDC.
Yeah, correct.
All right, so
KCDC,
then
Back in
just
Black.
a week
What a great
later,
album.
your attorney, Mr. Ritchie, gets a letter from Assistant United States Attorney Catherine Helopka Ivory, right? It's what's called a proffer letter. You know that term, right?
Correct.
So sometime in that week is when you must have talked to your lawyer, right?
Objection irrelevant. When he talked to his lawyer and calls
Well,
for
that question's all right. It's,
Now ask him what he said.
yeah, that's all right.
I believe so, yes.
Okay. So you finished with housing with Mr. Anderson. You talk to your lawyer, and 7 days after you leave his cell, you get this proffer letter from the government. Your lawyer gets the proffer letter, right?
I believe so.
Okay. So, and a proffer letter is an assertion by the federal government to say, we understand you want to cooperate. And if you do, we're going to sit down with agents and you got to tell us everything that you did and all the information you want to share, right?
Correct.
And what the letter says, it's I don't know if you ever heard the term transactional immunity. Have you ever heard that?
No.
Okay, so, but essentially they agree to not use anything you say in that meeting of you giving information against you, right?
Correct.
And it might be commonly known as being king for a day. Did you ever hear that term?
Objection, Judge. The circumstances of this immunity are irrelevant in a proffer letter.
Are they though?
Relevant.
They're directly
Depends.
relevant.
And I don't know. I've never seen it, so I have no idea.
Well,
Uh,
I'm going to show you what's been marked as Defendant's Exhibit 248. Is that the proffer letter that your attorney was sent you, or was sent?
I believe
well, your
so.
question's unclear.
Was this the letter that was sent to your attorney, the proffer letter on February 7th, 2022?
I believe so.
I mean, I'll stipulate that it appears that it's a letter sent to the attorney.
Okay. Move to admit the Defendant's 248.
It's got highlighting on it, with or without the highlighting.
With.
Oh, is there a clean copy in existence?
We can print one.
Well, a form of that letter is admitted unless there's objection.
Say it one more time.
A form of that letter is admitted unless there's objection.
No objection.
Okay. So the letter, first of all, you went over this, or you were given a copy of this?
I believe so.
Okay. And so, and they say specifically that in exchange for your client's truthful statement, the United States agrees not to use any information furnished by your client during the interview directly against him in any civil or criminal proceedings subject to certain conditions and exceptions. Does that sound right? Does that sound about what you remember?
So objection, and this has been asked and answered. He already asked him, were you offered immunity? And I believe he answered yes.
All right.
Overall.
Does that sound right from your recollection?
Yes, I believe
Okay.
so.
So that was on December 7th, 2022. not December, February 7th, 2022, right?
Believe so.
4 days later, on February 11th, you sit down with investigators Michael Seeger and Daniel Lagendorf and your lawyer to give information to help yourself on your federal case, right?
They came up and said they wanted to talk to me, and I did agree to talk to them, yes.
Well, it wasn't just a chance meeting. This was set up by your lawyer and the government, right?
I believe so.
Okay. Okay. And so the whole purpose of advancing this cooperation that you were purporting to do is to get you out from underneath those mandatory minimums, right?
Jackson, that's been asked and answered. He's already said that that was the purpose.
Yes.
So when you had the opportunity a year ago now, you sat down and you told them about a shooting at GRC bar in Racine, right?
Oh, this isn't his first snitch. He knows about
Huh?
all the crimes in the hood.
And
he knows about all the crimes.
that was where you and Mario Johnson and Akeem First were down in Vice Lord's territory, and Akeem First gets shot, right?
He didn't get shot in Vice Lord territory, but the cop said it was Vice Lord's territory, yes.
Okay. But he got shot.
He did.
And you were there.
Yes, we all were there.
And so you spent whatever amount of time it was sitting down with them to tell them that it was two individuals by the name of Andrian Harlan and Mark Geeter who were driving around and that they did the shooting. One of them did.
They asked me about those gentlemen, yes.
And you said that you think one was driving and one did the shooting because you were there, right?
I was there, yes.
And
Well,
but oh, sorry.
the question and the answer were not totally congruent.
Mm-hmm.
You asked him, was he there and did he do the shooting? And he answered, I was there, yes.
I didn't ask if he did the shooting.
Or you're correct. I apologize.
Yeah. So actually you said that Harlan was driving and Geeter got out of the car and shot, right?
I don't think I said he got out of the car and shot. No, because I didn't see that, but.
Okay. Yes. And the reason you didn't see it is because you were across the street urinating.
Correct.
And yet,
wow,
you still sat down with them and told them all of what we just discussed, right?
I sat down and told them what I knew of the incident because they asked me about it, yes.
Okay. And through that entire interview, just days after you leave Mr. Anderson's cell, you don't say a word about this supposed confession to a murder, right?
Well, they didn't come asking me about that. They asked me about a certain situation.
Okay. So, all through 2022, you're in custody at KCDC, right?
Correct.
And all through 2022, your attorney is trying to negotiate with the government about your involvement in that conspiracy, right?
I'm not sure what he was doing in
What
the meantime.
conspiracy?
The drug conspiracy. Sorry. You're not sure what he was doing?
No.
Okay. Maybe you just didn't have a lot of contact with him?
We had contact, but we wasn't hearing anything. It was just a sitting point for us, really.
But you were looking to cut a deal, though. You didn't really want to go to trial,
Cut
right?
a dildo, what?
I wasn't going to go to trial.
I'm sorry?
I wasn't going to go to trial against everything, no.
Because it was kind of overwhelming.
Correct.
And you understand that, and you understood that, you know, your only path forward was some sort of deal, right?
Correct.
And so flash forward to
Wait, are we watching the
January
same
of this
trial,
year.
Andrew?
I'm going to show you what's marked as defendant's 250. This is a letter dated January 20th, 2023, addressed from the federal government, U.S. Attorney Bridget Schoenhorn to District Attorney Michael Gravely about your cooperation, right?
I never seen this, but okay.
About you cooperating in this case. Is that right?
I never seen that.
Judge, he's just testified.
All right.
Yeah. He's just testified he's never seen it.
Never seen it. All right,
Yeah.
that's fine. So,
Well, don't comment on the answer. He stated he didn't see it.
Yep. All right.
And the objection is sustained.
but but at some point prior to January 20th, 2023, you communicated to your lawyer that you wanted to come forward about Mr. Anderson, right?
Yes, I did talk to him.
Right?
Well,
I'll
talking
follow
about
up.
conversations with the attorney again.
No, this is what he's saying, not what the attorney's saying.
Yes, and?
Right. Well, I'll cut the lawyer out. You, sometime in January of this year, so just a few weeks ago, advanced the notion, or had it advanced to the government, that you wanted to cooperate regarding this particular case, right?
Yes.
And you had just spent the last year wondering what's going on with your case. And so you're thinking testifying in this case might really help that whole negotiation, right?
Yeah, I brought it up to my lawyer and we talked about it, yes.
So,
Oh, Neil
that's a yes?
deGrasse Tyson, look how far
thought
you've fallen.
Participated in this case, cooperated in this case might really help you in your federal case,
He
right?
answered, objection, asked and answered. He said, I talked with my lawyer, yes. That's an answer.
Well, but there was, it had the taint of it that it was a reference, a conversation with the attorney, and Mr. Birdsall, I think, was trying to clean it up with the follow-up question.
Per the court's instruction, yes.
Yes.
Is that a yes?
Yes, I brought it up to my attorney.
Well,
We
we're
talked
not
about it, yes.
concerned about that.
Forget about your lawyer for a second.
Okay.
You specifically wanted to advance your participation in this trial to help in your federal negotiations, yes?
If it could help, yes.
And you feel like it will help because this is a murder case, right?
I guess so, yes.
So I'm going to show you what's been marked as defendant's 252. That's the plea agreement, the proposed plea agreement that you were going to enter into?
Correct.
You got that speaking to the
Did you
microphone.
inquire
Yes.
were or are?
Good
Was-
point. This is the one you intend to enter into, right?
That's the one that was brought to me, yes.
But the one that you want, correct?
I wouldn't necessarily say that's the one I want, no.
But it's the one you're going to do.
Ooh, you're the
There's a
one
few
that I
things
want.
I still got to argue in there, so I wouldn't say.
Sorry, a little
Yes.
grease there for
Okay.
a minute.
Well,
Sorry.
but this is the one that's at issue though, right?
That's the plea that's on the table right now, yes.
Okay, I would move to admit.
And I've got the grease soundtrack going through my
Any
head.
objection?
No.
Received.
So in that agreement, it has some notable things, and that is, right now, as we sit here today, you're facing the conspiracy charge, right?
Correct.
The substantive delivery of crack, right?
Correct.
And the felon in possession, right?
I'm not charged with felony in possession, I don't believe so.
Okay, so I'm going to show you from defendant's 252. Actually, I'm going to go back.
No, but you can trust this
Counsel,
guy.
I might have misunderstood
Yeah.
your question as well. Are you asking him what he's facing or what the plea agreement envisions?
Right now, I'm asking what he's facing, and then I'm going to ask about what he's going to get from the
All
plea
right,
agreement.
so that's,
I'm gonna
that's
ask
been
both.
asked and answered. He's already gone through the superseding indictment and asked whether Mr. Washington recognizes and understands each of the charges. So we've covered that.
So if I could, Judge, it's specifically, he wasn't sure. Just
Why
now.
don't you do this?
Yeah.
Ask him if he's aware of the difference in numbers.
In numbers.
Potential outcome.
Oh, yeah. Well, first I wanted to get establish which charges are at play here. And so you weren't sure about the felon in possession. Is that right?
It's really
Okay,
weird
so I'm
that
gonna
his
show
lawyer
you
chose not to show up today.
Page
Yeah, I wonder what's up with that.
4 of the superseding indictment, which is Defendant's Exhibit 247.
Again, we've covered this, Judge. We've gone
That's
through
some
the
shady
superseding
business.
indictment. He's gone through each
It
charge.
could be that his lawyer knows he's full of shit and cannot be in that
He
courtroom and
hasn't
allow
walked
his
through the
client to lie to the
He's,
court.
he's basing the question on other evidence as it relates to the witness's answer, which has most recently been given.
Correct. So I'm going to show you page 24 of Exhibit 247. This charges on or about October 20th, 2021, Marquand Washington, aka Munch. That's your street name?
Correction irrelevant what his street name is.
Wait, I
Part
thought
of
it was
the indictment.
Superman. Now it's Munch.
Knowing he previously
love
had been
this.
convicted of a crime punishable by an imprisonment for a year, for a term exceeding 1 year, knowingly possessed a firearm which, prior to his possession of it, had been transported in interstate commerce, the possession of which was therefore in and affecting commerce. Is that right?
Yes.
So that's what you're actually charged with right now as we sit here today, right?
I thought they dropped that, but
Well,
Apparently
that's
not.
what
Are you saying it's already been dropped or they're proposing to drop it?
I thought the plea arranged for that not
But
to
their
be.
plea
in there.
hasn't
You
gone
haven't
through
signed
yet.
it yet,
But the plea
bro.
that they had came to me with had removed the gun off there because I didn't get caught with a firearm.
The question is, because I
You
asked
don't
you,
have
if
a
you recall,
clue.
whether the plea had actually gone to court
Mhm.
with the judge and you had entered your plea, and I think you told me it had not.
Correct.
So you still have a pending charge.
Correct.
And until that time, whatever is charged in that indictment are the charges in the superseding indictment
Okay.
are the charges against you.
All right.
And I think what he's trying to do is to compare the potential outcomes between what you're charged with now, which will result in nothing unless the government can prove the case.
Right.
But if you're convicted, it could have a potential outcome. Or if you pleaded guilty, then you won't have any trial, and the judge will sentence you based upon your plea, which will apparently remove the firearms charge.
Okay.
He's been rickrolled.
So, but as it stands right now, if you were to go to court and you didn't plead guilty, the judge would have a trial and the jury would decide based upon the charges that are contained in the superseding indictment right now.
Okay.
He doesn't understand a word you just said.
So I will show you,
He certainly does not.
already been admitted as defendants 252. This is the plea agreement, right?
Yes.
And so what it says is that the charge is count 1 that you're going to plead to, right? The conspiracy.
Correct.
That's the one with the 10-year mandatory minimum, right?
Correct.
The other 2 don't have mandatory minimums, right?
I believe so.
And then if we look on page 3, in paragraph 8 of that exhibit, it says the government agrees to, as part of the plea agreement, the government agrees to move to dismiss the indictment and the remaining counts of the superseding indictment as to this defendant at the time of sentencing. Is that right?
Correct.
And the plea agreement also has a provision for relevant conduct, right?
Yes.
And you understand that relevant conduct in the federal sentencing scheme, when you look at the guidelines, it's all driven by drug weights, right?
Correct.
And so the higher the drug weights, the higher the penalties, or the higher the guideline range, right?
I believe so.
And so in your case, they are, you're agreeing when you sign this, if you sign it, that the defendant is responsible for at least 3,000 kilograms, but less than 10,000 kilograms of converted drug weight. Is that right?
Yes.
And what they base that on is multiple different drugs, and they have a formula that comes up with that, right?
I believe so.
So, but specifically 30 kilograms of cocaine and 400 pounds of marijuana as part of your taking responsibility in the actual case, in the plea agreement, right?
Yeah, that's what they want me to take responsibility for.
Right. And they dropped all that crack stuff, right, as part of relevant conduct, right?
Right.
And your base offense level, you're agreeing, is 32 under the guidelines, right?
Correct.
So, but if we look on page 6 of this exhibit, just to be clear, 252, in the guidelines, you're a career offender. Is that right?
I qualify as one, they say yes.
Okay. And a career offender is somebody that,
Objection. Again, why he qualifies as a career offender is not relevant to whether he's honest or not.
Yes, it is.
So what he's charged with.
I'm not talking about why he qualifies. I'm talking about the effect of being a career offender.
Well, no, your question actually did.
I can rephrase. No
Go
problem.
ahead.
So, but if you sign this, you agree that you understand that the probation department, the United States Probation Office, they will do a guidelines calculation, right?
Correct.
And they've already told you that you're a career offender based on your criminal history, right?
Correct.
And so are you familiar with the guideline chart?
I've seen it, yes.
Okay. So I'm going to ask you if that's what we're talking about?
Yes.
Okay.
Yeah, the DA
I'm
still
going
is
to
being
move to
responsible.
admit, I believe, defendants 253, which is the guidelines chart.
Is there objection?
No.
Received.
All right, so I'm putting it up on the chart here. So here we have two axes. On the left is the offense level, right?
Counsel, I'm going to approach just
Yes.
close enough so I can see this because the writing's.
Yeah, it is.
I apologize for approaching.
That's all right.
I didn't hear your answer, I'm sorry.
Yes.
Okay, so this is the offense level, and this is the criminal history category, right?
Yes.
And it's those two numbers that eventually find their way into a guideline range of potential imprisonment, right?
Yes.
And in your case, because you're a career offender, you're automatically in category 6. Is that right?
Correct.
Okay, maybe pull it, yeah.
Correct.
Yep. And under the plea agreement, you are looking at a base offense level of 32, right?
Correct.
Except because the offense that you're going to plead guilty to has a maximum of life, your actual offense level is 37, right?
No.
Well, it's one of those, if you're 32 in category 6, your potential imprisonment is 210 months to 262 months, correct?
Correct.
And that's your understanding.
Correct.
And so that is different than the mandatory minimums, right?
Correct.
The mandatory minimum would be 120 months, right?
Correct.
But you're potentially facing up to 262 as a suggestion to the judge per the United States Sentencing Commission, right?
Those are the guidelines, yes. But if I accept my plea, it's 3 points knocked down as well. So
Right. Right. If you accept your plea, they take you down 3 points.
So
let's
that
just
is
do
why
the
you're
math
lying
here.
about everything,
It'll
because
take
you
down
want to
to
be knocked 3
level
points.
29.
That halves your
And that'd be
prison.
151 to 188.
correct.
Is that your understanding?
Yes.
Okay. And by when we say coming down 3, that's called acceptance of responsibility, right?
Correct.
And that also is a motion by the government to take that down 3 levels, right?
Correct.
And so on 2 levels, in 2 categories, you're depending on the government being pleased with your testimony here today. Is that fair?
Yeah, I guess so, yeah.
Okay. Because on 1 level, you want to bring down your offense level for the guideline range, right?
Yeah.
And on another, and bigger and more important, is you want them to make that motion to Judge Edelman to get you under the mandatory minimums, right?
Yes.
Because, as you said, you just don't deserve it, right?
Oh.
Correct.
Burn.
Before you sat down with the government, they had advised, well, you knew that they knew about certain things you had done both before you were arrested and while you were in jail in KCDC, right?
What do you mean while I was?
Well, specifically that you and another person had threatened a confidential informant during the investigation of a case against you in 2020, right?
No. That's the
Aussie
same
Overlaw'd
thing
in
you asked me about earlier when
Hey,
you said
welcome.
that we was riding around with guns.
Welcome,
Stuff like
Hayden.
that.
Okay.
Correct.
So they're saying you threatened and you're saying you didn't.
Correct.
Okay. So, and then in 2022, while you were at KCDC, they discovered you had a USB drive in your cell, right?
Correct.
Something like this, right?
Correct.
And that contained the discovery for your case, right?
Yes.
And there was the judge had signed a protective order specifically barring the copying and sending out of the discovery materials, right?
I never seen that, but
okay.
It wasn't
Well,
illegal.
they discovered you had it and they confiscated it, right?
Great.
They came for something else, some pornography or something somebody else had going on, and they took it, and I haven't received it back. But I have been asking for it back because
Give me back my
it is
pornography.
mine, and I can't have it. So
Well, you
Give me
can't have
back
it
my
because
porn.
a federal judge entered an order saying you can't have it.
Well,
I
objection.
never
Hold
received
on.
that order.
Objection. He has already testified. He doesn't know that.
He didn't let me finish my question either.
Well, but let's go back even step back more. The discovery that you're referring to is the discovery in the federal court case,
That's
not the case here.
That's correct.
All right. And
have
so
been clearer
why
about
don't you start over with a question?
Okay. So the USB drive you had in your cell was for your conspiracy case, the federal conspiracy case, right?
correct.
And you're saying you didn't know anything about the protective order.
Never got it.
Okay. You never, not to talk about, like you were never advised by anybody that you weren't supposed to have this?
Lawyer never mentioned nothing like that to me.
Okay, so because there's federal inmates at KCDC, they make arrangements, the federal government makes arrangements for defendants to have access to the discovery, right, in a separate room, right?
Correct.
And so How did you manage to get a USB with all of your discovery despite the prohibition?
We can buy them, but I bought an extra one from Mr. Anderson.
So you bought a USB drive and you went into the separate room to look at your discovery and you made a copy of it?
Correct.
Okay. So now that's been confiscated from you, right?
Correct.
All right. So in January, you had an epiphany about talking about Mr. Anderson's case with, so that you can get help on your federal case, right? We've established that. I'm sorry. I'd like to finish my question, if you don't mind.
Well,
I'd like to finish my question, Judge.
I'm objecting to the term epiphany, which was the beginning of the question. It's argumentative.
Well, it's a word that's frequently misused. So I don't actually know what he's looking for.
How about you let him
means,
finish the sentence?
Manifestation. And so I don't know. That's kind of a
epiphany means awakening.
You must have one of the brainiacs because
Realization.
that only they studied Greek when I was in school.
Okay.
Start your question over.
All right.
It's a moment of profound realization
January, you
that
decide
changes
you're going to
your
advance
course.
the ball on Mr. Anderson's case to help your federal case. We've established that, right?
Yes.
Okay. So then on January 17th of 2023, just, I don't know, 3 weeks ago or so, you sit down with some police officers and the district attorney, right?
Correct.
Specifically, you were sitting down with all of the people at this table, right?
Correct.
Detective Carrera, District Attorney Jessica, kept on your name, Krizarek, and District Attorney Michael Gravely, right?
Correct.
Those three people at this table.
Correct.
And also, Detective Warren Anschutz. You remember that name? There's another person there?
I believe so. I don't remember the name, but
Was your lawyer there?
no.
He was not there for this interview?
No.
Okay. But you sat down at the Kenosha County Jail, right?
Yes.
And you met with these three individuals for about an hour and a half?
I didn't count the time, but I'm
Sound about right?
I spoke with them, yeah.
Okay. And as you were being asked questions, who's doing the main questioning? Mr. Gravely?
Correct.
Okay. Was that like exclusively throughout the interview, or did the others kind of like chime in once in a while?
Everybody spoke up, yes.
But it was mainly Mr. Gravely?
Yes.
Okay. And he made it clear to you that he was very interested in having you come here, right?
He wanted to hear what I had to say, yes.
And that after you testify, he's going to report back to the United States Attorney about how well you did, right?
My lawyer said he probably would talk to him, but
Well,
yes, he didn't really, I didn't ask him that.
Okay. But that's what you're hoping for.
Objection. We've covered this area. What he's hoping for, asked and answered.
Overall,
Yes?
Yes.
All in service of getting you out of the mandatory minimums and possibly the 262 months that in theory you face, right?
Whatever it would help with, yes.
In fact, the charge against you actually has a maximum of life, right?
If I go to trial, yes.
Well, whether or not you go to trial, it's still a maximum of life potentially, right?
Correct.
And so the guidelines say one thing, the mandatory minimums say another, and you're trying to get down to something where you can get back on the street, right?
Yes.
Just one moment, Judge.
Okay, well, he's one momenting here. Howdy, Hayden. And Durna 1804 says he said he would fight his cellmate if he snored, but also he slept like a baby, but also his cellmate screamed in his sleep. Seems easy to impeach to me, and he's going to be marching all over his head for quite some time to come, I think, here. Wrestler Town. So it's fine. Wait. Yeah, okay. So it's fine if the government holds additional penalties if the witness exercises his right to trial, but a violation if the defense asks about it. Nicholas Starov, he's a serial snitcher. Yeah, this ain't his first time around. As they were saying, he talked about the murder while he was taking a piss. The Z-Man. Wait, those are protected? Last trial I watched, they weren't. Attorney-client privileges you were talking about there. Did his attorney purposely not show up? I have my theories. We'll talk about that. 300 people lied about hitting the like button. Oh, yeah, the like button. We'll talk about that in a second, too. Thanks for that super chat. Execution, change chat name banner to Vice Lord. Ain't never going to happen because, you don't joke about belonging to actual real gangs. They tend not to like that. And chances, never mind. It ain't gonna happen out of respect and the proper thing to do. It's just a thing. Kelly R. He'd throw his own mother under the bus for a plea deal. Oh hell yeah, of course he would.
Probably. That's
what jailhouse snitches do. Chaos coordinator with a Rickroll. Never gonna give you up. And Snitch McSnitchin, smooth criminal. Smooth operator. I love me some Sade. Chaos coordinator. Sade is so damn hot. She's like 60 years old and she's still smoking hot. Southern mom. Anyway, I digress. I'm not really digress. I'm just going off the rails. I'm on crazy train. What is substantial cooperation? Seems like this witness / jailhouse snitch is not doing himself any favors. Well, he's giving substantial cooperation by toting the prosecutor's line.
Just a couple more, Judge.
It's interesting.
It's technically referred to as substantial assistance.
When you had the drive, this was actually, I'm just using this as an example, but when you got the drive, when you're in your cell, you got that from Zach, right?
Correct.
And in fact, you stole it from Zach.
I know, but I like smooth operator better. That's why I'm saying smooth operator. And
there was
Michael
already
Jackson,
material
smooth criminal,
right?
Zach removed the material from it and sold it to me, yes.
Okay. So if the government who seized it found that Zach's discovery was on it, in addition to your discovery, you'd be surprised to hear that.
Yes, I will be.
Okay. I think
I changed it on purpose.
I also sent money to Zach for that.
Dorks.
I just need to move in Exhibit 250. Is it the Proffer letter or the letter to Mr. Graven?
Is there objection?
No. Or didn't you hear me sing actually smooth operator, not smooth criminal?
That's all.
Thank you.
All right, there we go. That was weak. That was kind of actually weak. I did not like that. Oh, I liked what he did. He just should have done a lot more.
Is it your understanding that if you lie
I agree.
like this, your entire agreement is blown?
Yes.
Is it your understanding that if you give false information to the DA's office or any other place, your entire agreement is blown?
Yes.
Pardon me? Well, his credibility has certainly been an issue. Overruled.
So if you tell a lie here, or if you tell a lie to law enforcement in a meeting, etc., then all of those consequences that we're talking about by the defense are things you're going to have to face. Isn't that right?
Correct.
Nothing else.
Any question?
No. Okay.
All right, let's break at this point. Please don't talk about the case during the break. Read, watch, or listen to any account of the trial. Informational. We'll be breaking for the day around 2:30 today. Okay. Any questions, anybody? And I'll get you more information about tomorrow as soon as I get it. Okay, thank you.
Wow.
All right. That was kind of weak.
I'm troubled by that last little reveal that the snitch had all of Zach's discovery.
Wait,
How
what?
did he get it? Did Zach give it to him? The hell's going on there? Yeah, there's a little mention that he had Zach's discovery.
Yeah, I find that very disturbing. There's no reason that a witness should have access to something like that. Did they really say that? I mean,
And unless Zach was dumb and gave it to him.
That's profoundly problematic.
Did he just admit to having Zach's discovery? Isn't that? Yeah, it is. It's actually kind of big.
I have a hard time believing it, but I mean, it was stated.
Zach probably had it there, and he probably read it or looked at it or did some shit, or maybe that's what he downloaded onto his USB. Zach is saying the USB was stolen. Yeah. Anyway, that's weird. Whatever. That's just weird. I think it proved he stole the USB. Yeah. Thank you, Tanny Simmons. Wait, what are we talking about? Ooh, something about a juror. Guy playing with the audio. Whatevs. All right. Well, let me quickly burn through the last 4 super chats I've got here from a million years ago. Chaos coordinator. This witness is
aware of whom he speaks?
I release them, or do I need to hold them?
No, let's move Mr. Anderson now. So you can hold him just a few minutes.
Oh, don't tease us. Huh. Okay. Chaos coordinator. This witness is killing my 2 remaining brain cells. Murdoch trial killed most of them, sadly. Let them live, I beg you. Mangs. Thank you so much for the super chat. How can the defense bring in this BS evidence last minute? This jail buddy is not believable. It's not really last minute evidence. I mean, they've had it. This guy's been on the radar for a long time. He's been negotiating a deal since like a year and a half ago. So yeah, this isn't a last minute thing. This is the state's case. This guy, basically, this is the only one that can provide evidence of Zach being involved in this murder, allegedly. And yeah, we'll catch Hayden up on this bullshit.
Sounds like it was a fun morning.
Oh yeah, unhung hero. They axed him by axing the tough questions. Yeah, we're not doing that again. We did that on purpose. You just need to deal with it, chat. Otto Rommel. Okay. I believe they said that he had his own discovery in his federal case where he was threatening a witness. It doesn't matter at this point. This guy's such a toolbox. Wow. Wow. Yeah. Wow.
So it appears there's a bit of back and forth in the chat about whether he had access to his own discovery or Zach's discovery. So to clarify,
maybe I misheard, but I thought he said he had Zach's. I mean, obviously he's going to have his own, but I thought I heard him say he had Zach's, but I could have.
that was what I heard as well. I think that he was talking about a USB drive that belonged to Mr. Anderson, so that would fall in line with the idea that he did have access to Zach's discovery.
I mean, I was here for all of 5 minutes to catch the end of it, but it's made it sound like he had Zach's discovery. So whether he misspoke or whatever, that is definitely how I came across. So,
and why is it always Wisconsin?
It's the cheese.
He had both. That's what I mean. He's obviously going to have his own. It was a thumb drive with both his and Zach says. I think he went to the other room. He copied it on the zip drive, on the USB drive. Zip drive. God, how old am I?
So there was discovery for his own case and Zach's case on the same thumb drive. See, I don't see him having access to his own discovery problematic, because if he's
he's
the
supposed
defendant in a case, he should have access to his own discovery. That's
See,
not
and
problematic, and there's no need to testify about it.
And this is what I understood. He had both. Zach's discovery was on the USB drive confiscated by the feds because the snitch wasn't supposed to have a copy of his own.
Well, who messed up?
But you have to have a copy of your own. That's your right.
And the theory was that he bought
Chris
it
Mull still
from-
calls them zip drives. You're old too.
I
Yeah,
guess
he
the
said it was
question is,
Zach's drive. All right. That's
how
what
did he
everybody's
come to
saying.
how did he come to be in possession of it? It sounded like it was either bought or it was stolen. Zach's impression, Zach gave the impression that he had it stolen from him. This guy said he bought it from him.
Yeah, either way, he admitted to copying it. So,
Right.
all right. Well, I guess we're caught up here on the super chat. We've got everything taken care of. So let's get ready to rumble over on Aussie's channel, and then I'll switch on over to Aussie Overlaw'd. That's what we do. He takes the lunch break in the afternoon session, and I go to sleep.
Sounds like it's going to be a fairly short one today, so that's going to be interesting.
And there may not be court tomorrow because there's a big snowstorm coming in. No, the judge said he'd let him know at the end of court today.
Oh, okay.
Yeah, Tanny Simmons, he's allowed to have access, but he's not allowed to download his discovery or share the contents per federal order. Okay.
Right.
Seems reasonable. Because the USB would be contraband, I guess. Whatevs. Did he store the USB in his prison port?
Well, he had to put
All
it
right.
somewhere.
While Aussie's getting things set up and ready to go, let me double check to make sure. Yeah, we are scheduled to feed directly into him because I do the morning sessions while he sleeps, and then he wakes up and we do the tag team thing, and he takes the lunch break and the trial for the day. And so when we wrap up here, that's what's going to happen. We should go automatically over to him, and I'm just triple checking to make sure. And I'm glad I triple checked to make sure because I was incorrect. You don't have it set up yet. That's why. Let me know when it's set up. Huh, you're not even upcoming.
On a second.
Yeah. All right. Well, while we're waiting for something to happen, it's still not coming through. Let's do this. Let's shut down the like and subscribe poll. Currently, we've got a bunch of people here. And I'm backtracking here. Give me one quick second so that we can make sure this goes smoothly. Hopefully. Because it always goes so well. All right, we've currently got 1,783 people here and 1,220 likes. Everybody, make sure that you hit the like button. And I am 26 people away from 35,600. So if there's like 26 of you out of the 1,700 that haven't subscribed to me, I would be super, super grateful if you would do me that favor. I'm hoping to get to 36,000 by the end of next week. So if 500 of you haven't subscribed to me, everybody give 500 of you hit that like and subscribe. We have our little poll here, so a little lame little poll that annoys everybody, but we do it anyway. 16% of you said you hit the like and subscribe buttons hoping to find an orange in your robe. And 20% of you said you hit the like and subscribe button, so there will at least be some DNA in this case. 31% of you said you hit the like and subscribe button, so the DA will stop yelling at you. And 1% in the lead with 32% of the vote. I hit the like and subscribe buttons. Objection asked and answered. There we go. That's the end of the like and subscribe poll for today. Tomorrow, if there's court, I'll be back here. Kind of hope there's not because I'd like a rest. It'd be nice to get a good night's sleep. For Saturday, I'm going to be heading up to Seoul to hang out with Legal Mindset Andrew. We're just going to get liquored up, and we might do it. We might do an impromptu stream at some point. Monday, we'll be back with more trial. As I said, I've got something going on Monday evening, so I won't be able to do Maritime Monday. It'll either be back on Tuesday or a week from Monday. And let's see if we've got Aussie sign. Let me pull this back up and see if we're credited with you so that we can feed into you, Hayden. And congratulations on the 10,000 subscribers.
Thank you very much. Appreciate that.
Yes, congratulations.
Let's customize me here. Aussie Overlaw'd starting live. All right. Save. And we're ready to go. So please do me that last little favor on your way out. Hit that subscribe button. Let's get me up to 35,600 with 24 more subscribers. Love you all. You guys are great. Mods, thank you for doing everything. It's a pleasure to have you here as always. Vice Squad, you are the greatest chat on the internet. And you include Hayden. So Hayden's is great too. And Chandler, as always, thanks for being here for the OJ earlier and for being here for this.
Thanks for having me, as always.
I guess we'll all see everybody over there on the other channel. Let's see. Make sure we've got everything. Oh, here we go. Dump me properly, Jeff, says Chaos Coordinator. And in the grand scheme of things, it doesn't matter whose discovery he had. The guy's still an asshole, and he's a liar. I don't care whose discovery he has, really.
Right. I mean, we're basing this testimony off of what? A nightmare and a nickname.
Yeah. Hayden's gonna love that.
Really compelling. Oh, I know he's gonna have a blast with that.
And with that, let's wrap this up and head on over to Hayden and join him for the lunch break. I'll update him on what happened, and then I'll leave it to you two to carry through the afternoon.
All right, I'll see you.
So good night, everybody here. We'll see everybody on the flip side. Catch you tomorrow if there's court. Otherwise, we'll catch you on Monday. Talk to you later. Bye.
Bye, everybody.